Everybody, it's time for the afternoon session to resume with the second round table of the day. Although the agenda that we've circulated for this, I think, is slightly longer than the one for this morning, I'm hopeful that we'll get through it more quickly. I think there are just a few points that we do need to cover, but hopefully there won't be the same detailed discussion that was necessary this morning. Just 2 points by way of a start. Just a reminder, because I know I'm conscious that there are additional people here this afternoon. The discussion on the order being a round table means that it's an open discussion. As long as they indicate, anybody can participate with comments that they wish to make on the draft order and the associated documents. So please feel free to take that opportunity. And the other point is just to check who knows. I'd just like to check who knows that they're going to participate in this part of the inquiry. Now, for the applicant, Mr. Cameron, will be
It'll
yourself
be
and
me, and it will also be Ms. Redman, who is a partner in Womblebond Dickinson, who appeared at the first round table on the order.
yes, I remember that. Ms. Redman, can you just give me your initial, please?
Yes, it's V for Victoria.
Thank you. And did Mr. Cameron say you were your partner to one? Yeah. Thank you. And the local authorities.
Thank you. I don't anticipate I'll need to say anything.
Right.
But,
Okay, Mr.
I'm here
Cameron,
in case, just
yeah,
in case there is
okay,
anything.
just keep a watching brief.
Yes, indeed.
Mr. Parker's already indicated he doesn't intend to participate. Anybody else know that they want to say anything about the order? Well, there's an opportunity if you so wish. As Mr. Cameron mentioned just now, we did have an initial session when the inquiry was just getting underway about the order and discussed certain changes at that stage. And it was made clear then that there would be a final session on the order shortly before the inquiry drew to a close. We're at that stage now, and a number of additional documents have been submitted, and I think now are all on the inquiry website if you wish to check them. The key document that I want to go to is the updated schedule of changes, which is the key thing at this stage. And I think first time round, when we talked about proposed modifications to the order, they fell into three categories. Mr. Cameron will correct me if I'm wrong on this. There were points that were being addressed because they were simply corrections or typographical errors. There were a number of other points that had arisen because the applicant had been discussing matters with other parties, essentially protective provisions, I think, concerning the Environment Agency and statutory undertakers. And then there were a couple of articles which, in effect, the applicant had decided were no longer necessary or appropriate and therefore were intended to be removed from the order. So that's how things stood in the middle of September when the inquiry got underway. There were no points made at that session that any of these suggested modifications were material, and no objections were recorded to them. Now that we're 2 months further on, there is the schedule that's been put in. That provides a list in reverse chronological order of the various modifications that are being proposed to the Secretary of State in terms of the order. And my reading of it, Ms. Redman, is that there is simply one further proposed amendment. And it's not an amendment that, on the face of it, would increase the impact of the order. So it refers to the removal of plot 9095 of St. Neots Road a plot that was intended to be required for works and further consideration. That's no longer the case. So the intention is that that would be withdrawn. I just have one query, Mr. Edmund, on that. The schedule refers to plot 9095. The accompanying note from your firm refers to that plot 9096. So my question is simply, is it one plot or two plots?
So it is only 9095 because that's the only plot which is referred to in the order which is being removed. Both plots are being removed from the book of reference and both plots are shown as being removed on the plans, but only one plot is referred to in the order.
Right. So there's not an inconsistency there.
No,
that is deliberate.
That's deliberate, yes.
And follow up to that, have I overlooked anything? Is there anything else that's
no? There's no
changed
other
in terms of the order.
No other changes, sir. If I could just draw to your attention one matter which is related to the change to the National Highways plots or the removal of the two National Highways plots, and that is that when you receive the associated plans which show that removal, you may see that adjacent to those two plots there is another plot which is 10117.
Let me just get that number down.
117.
Yes.
And it may appear when you look at it that that plot has nothing on it, but it does in fact have something on it. It does have structures creeping into it. And so I didn't want you to see that plot and think maybe that should be removed.
Out as well.
It is intentional that it remains in. So the only plots which are being removed are the two that were previously discussed, I think, at the inquiry in relation to the National Highways land.
Right. Right, and the next thing that I wanted to check was the publicity in terms of what the proposed content of the order is. I presume, as the documentation I think came through to us yesterday, that the publicity is simply in terms of including those documents on the inquiry website.
Yes, that's correct, sir.
And are any of the modifications that have been put forward since the order was first made considered to be material at all?
No, sir.
And presumably, in view of that answer and what you've already said, changes since we discussed this last in September, I presume not considered material at all.
I think,
Mr. Cameron, please.
I was going to say what they do not do is extend the scope of the order.
Yes. Yeah.
Which is the way that I would put it. And that comes from the way that these things were dealt with in Parliament before they became Transport and Works Act orders.
My reading of what we've been told is that the reverse is probably true.
Yes, I mean, it reduces the scope, for example, in removing plots.
Yes.
Or removing articles.
Does anybody present have any comments or queries about the proposed modifications? Okay, thank you. Right. I think we may just have one or two detailed queries, Mr. Redmond. Yes. You'll see one of the early items on the agenda refers to plans and drawings. And Article 2, which is just off the page, towards the beginning of the order, defines deposited plans, means the plans and drawings certified by the Secretary of State as the deposited plans for the purposes of this order, and it refers to section drawings, engineering drawings, rights of way plans, special category land plan, crown land plans, and the works and land plans. But the question is, rather than or in addition to that reference there, should there be an accompanying schedule which is the same as the one that we discussed this morning for the request for deemed planning permission?
So I don't think it would necessarily be the same if you did want to put a schedule in, because I think some of the plans referred to in the deemed planning are not necessarily referred to in the order. So I think it would only need to cover what is certified under the order. If you felt it appropriate, that could perhaps be added to article, I'm just looking for it, Article 56, certification of plans. There could be a list of which plans are included there if you think that was appropriate.
I just wondered, we wondered if that would simply increase certainty as to what was involved.
Yes, I can see it would give you a single list, which might help rather than having to cross-check against what is in the in Article 2.
Is that something that the applicant could provide?
Yes, absolutely.
Yeah, I think also it's the same point that this morning, that obviously some of the drawings have changed, albeit sort of in a minor way, so they're not technically really the deposited plans anymore. So I think a schedule would help. I realise in terms of definition, the definition is based on what the Secretary of State may certify. So it also provides clarity to the Secretary of State should the Secretary of State make the order. Yeah.
Yes, sir, and they will be the deposited plans. We understand your point, sir, but have the list. In fact, the definition doesn't need to change because they'll be the ones certified by the Secretary of State.
It's just being absolutely clear as to what
just having
those
a
are.
list. Yes.
I understand that. Yes, thank you. Second query concerns the term ancillary works, which appears in the order, but I don't think it's defined. Sorry, I'm having to hop around between documents.
So I'm just looking myself now, but I think it is covered in Article 5.
Let me just, sorry, I was looking in interpretation, which is Article 2, I think.
I think under Article 5 there is a list of what are the ancillary works.
Let me go down then.
So
starts off with the scheduled works, doesn't it?
Correct, and I think if you look at Article 5.5, yes, Article 5, paragraph 5, it talks about the undertaker may carry out and maintain such of the following works as may be necessary or expedient, or for purposes ancillary to. And I think it's intended that is therefore the list of ancillary works.
It's not written in quite the same terms, is it?
It's not defined as such, but it does give you an understanding of what those ancillary works are.
It doesn't necessarily give you the impression that it's only those that could be ancillary.
No, that's
but that's the answer to the question.
Yes.
And also Article 5.3, when the undertaker may, on the land specified in columns 1 and 2 of Schedule 2, acquisition of certain lands for ancillary works, carry out and maintain any works specified in relation to that land in the column in the schedule. So they will be specified in that reference to ancillary.
Yes, so in terms of specific instances, this is clearly set out. Yeah. Okay, thank you for that. There's just a general heading on the agenda about the articles. Are there any specific points, Mr. Redmond, that you wish to draw out to make sure that everybody... There are a couple of seats at the front on this side of you.
No, sir. I think beyond the points that we discussed at the last hearing, there's no further changes to the articles.
Okay. Let me just go to the... So I want to go next then to Schedule 1, which I think is the scheduled works. And we raised a query, Ms. Redmond, which about the work number 1, which is the stretch of the guided busway at the western end in Cambourne, because there's provision made for this in a separate proposal to do with development of land at West Cambourne, and a note's been submitted which addresses this point. What I'm not sure about is whether it answers the question which I think we were putting last week, is why it's necessary for this stretch of the busway to be covered by the order. What we're told is that the planning obligation that exists requires the provision of this stretch of the busway in connection with the development of the housing which is going ahead, and that on completion that stretch of busway would be transferred to ownership of the council. So it seems, given the progress that's being made in terms of further development at Cambourne, it seems that is in hand in any event. Is there anything extra that the order provides that isn't covered by what currently exists?
So there is, because the order allows the council or the applicant to undertake the works as opposed to the landowner.
Sorry, allows the council...
Allows the applicant to undertake the works rather than the landowner. So at the moment, the applicant is reliant on the landowner undertaking those works. And if they are not undertaken, then...
But I think they've got to be undertaken before any of the dwellings can be occupied.
Well, the agreement would need to be enforced potentially, whereas what this does is it does allow the applicant to undertake those works without necessarily going through any enforcement in the agreement.
Is there a suggestion that something may go wrong in terms of the planning obligation?
No, there's no suggestion that anything will go wrong, but it is a necessary backstop.
Is that the sole reason?
That is the reason. It wasn't felt necessary, however, to include the compulsory acquisition powers because there is a requirement for the landowner to transfer that land, yes. And it wasn't felt that the test for compulsory acquisition could therefore be made out. But nonetheless, it was felt that a provision should be included to ensure that if those works didn't proceed for any reason, the applicant would be in a position to undertake them as part of the works under the order.
Mr. Cameron, you're going.
I'm just going to add, in the note that we put in,
yes,
attention was also drawn to the article which provides a defence to a claim for statutory nuisance, which wouldn't apply if that part of the busway was not covered by the order. And in addition, as you know, that we have a request that a direction be made that planning permission be deemed to be granted.
Yes.
And as we discussed right at the beginning of the inquiry. The terms in which that request is made is pursuant to Section 90, subsection 2A of the Town and Country Planning Act 1990, which is that the Secretary of State may direct the planning permission for that development, and that's development for which the order makes provision.
Yes.
So it would then be excluded from the request for deemed planning permission
And conditions
as
that we were
well,
talking about
and
this morning.
conditions.
Yes. We thought that might be something to do with it.
And so that is another reason why it should be included. And all it does is to authorise the provision of a busway on that part of the route.
Yes.
It doesn't confer powers of compulsory acquisition. And therefore, in addition to the reasons that Ms. Redmond put forward and the reasons in the note, that is another reason for including it in the order, because it then will fall within the definition in Article 2 of the busway. And the reason for doing that is that we do require, or on any linear route, the applicant has to be competent of carrying out the works on every part of the route.
Yes.
You can't have a gap.
Yeah.
I'm sorry, and also just going back to the point about the need for conditions to apply. I'm right in thinking that, of course, the hours of operation, there's no such conditions on the outline and the permission, the reserve matters for that link, is there? I don't think.
I'd have to check that.
But it wouldn't be in the terms that Mr.
It won't be in the same
yeah.
terms.
Thank you.
Thank you for those comments. Can we just stay with the note and just turn to something which was also touched on this morning, and it's the situation at St. Neots Road and the veterinary practice. And reference is made to the agreement, and the note concludes by saying, should the applicant enter into the agreement, which is clearly the intended position from what we heard this morning, it's not considered necessary to amend the order to repurpose the existing lay-by. This can be dealt with outside of the order application by making a further traffic regulation order to revise the waiting restriction. And the question is simply this: given that conclusion at paragraph 1.5, does that introduce an element of uncertainty, notwithstanding the agreement that we understand is ready to be sealed? And that you've got to go through a separate process?
That there is a requirement, or there would be a requirement to effectively change the waiting restriction.
Yes.
So at the moment, under the order, there would be no waiting in that location. So that would need to be effectively amended.
In the order?
Well, if it was to be dealt with in the order, it would need to be amended in the order, but it can be dealt with outside of the
Yes.
order by making another traffic regulation
Yes,
order
and
to
that's
allow
what
for
you
that.
That's what the note's saying.
That's what the note says, and that is the position that's been agreed.
And the question is, can you, if that process has to be gone through, can you be certain of the outcome?
Well, I think we can be confident of the outcome in the sense that it's been agreed in principle by the applicant. We know that it is something which is supported by the veterinary practice,
Yeah.
and we are not aware of any other highway issues why it couldn't proceed on that basis,
Right.
because there is already, as you know, an existing lay-by there.
Yes.
So we don't see that we don't consider there would be a high risk that would not be granted or made, I should say.
Mr. Cameron.
And of course, if a road traffic regulation order was made, the proper process would have to be gone through.
Yeah, exactly.
And as I understand it, the agreement with the veterinary practice recognises that and recognises it is subject to going through that order.
Yes.
And
Yes.
I wouldn't want to say anything which would suggest that the county council would predetermine anything,
Yes.
but
Yeah.
the county council has entered into this agreement.
Yeah. Thank you. Then. And then I think there are just a few detail points to raise if I can find them. Just jumping back to work number 1 and schedule 1. There's reference there to a two-way busway, I think. Elsewhere, there are references to guided busway. And it's just the question that I think we've made in collection of conditions a few times about the consistency of terms. Should the references always be just to busway or to guided busway?
I'm sure Mr. Redmond will have an answer, but guided busway is a defined term in Article 2.1.
Yes.
So when those words are used, it the definition applies.
It's just a case of, is there a particular reason why the link between Stirling Way and Broadway is just a busway, whereas every other thing is a guided busway, or is that just an omission?
I think I may need to check that, because it may be the way that the way it's been drafted, because of work number 1 being slightly different in the sense that it's provided for under the Section 106 agreement. So I think that's probably something that I would need to.
But in terms of your proposal, you're not relying on the Section 106. We know it's there. You want to include it as part of the overall scheme.
Correct.
From Stirling Way to Grange Road.
Yes, I don't disagree. I just want to double check that there would be no unintended consequence of including the word guided in there.
Okay. Okay, thank you. And there. I think the only. Go on, Jeffrey. Yeah. Yeah.
So again, can I just clarify again, just going back to Article 2, there's a definition of longitudinal sections, which means longitudinal sections included in the deposited plans. We've already discussed what deposited plans are. Section drawings means the deemed planning proposed site sections and the longitudinal sections included in the deposited plans. It's what's the reason for that? What one's talking about the section drawings, which appears to cover both site sections and the longitudinal sections, and longitudinal sections is defined as being longitudinal sections. I just wondering what the significance of that is. And sorry, I haven't identified a particular article where there's a different approach there.
I'm just looking at the articles, and certainly Article 5 refers specifically to the section drawings in terms of the level shown on those drawings. So I suspect it's because they have particular levels on them which are linked back to Article 5 and Article 6. So Article 6 deals with the limits of deviation. And so I suspect that those plans need to be specifically referred to in that sense.
And I suppose the other question is, you've already mentioned that the reason the schedule may well be different between any schedule that goes into the order and the conditions is that it doesn't refer to the deemed planning drawings, but is there not a reference here to the deemed planning drawings?
Yes, there is, and I think some of them it does refer to and some of them it doesn't.
Okay.
So what I will do is when we compile that schedule, I will make sure that we've got all the right ones in there.
So
Yes.
check the whole thing, but I think you will find that the references in the articles, including the ones that Ms. Redmond has referred to, Article 5.2, Article 6.1b, refer to the section drawings. And the section drawings, as you've pointed out in the interpretation article, are the deemed planning proposed site sections and the longitudinal sections included in the deposited plans. So they bring the two together, and then when they're referred to in the articles, they're referred to as the section drawings. So that's why you need both those definitions.
Thank you.
You may well tell me there's a similar answer to the next query, which it's Article 36 when I get there, which deals with open space land, and it refers to the exchange land and the DFT exchange land. We're right in thinking it's exactly the same thing. I can't find it in the interpretation article.
So at the end of the open space land article, there is a definition of the DFT exchange land and the reference to the relevant plot in
Yes.
paragraph 8.
Right, so yeah. So it's covered there rather than as part of the interpretation.
Correct, yes.
I think because it's specific to that
Yes.
article rather than applying to the whole order. And it actually gives you an answer on sequence as well.
Yes. I think we've covered the queries we specifically had for the applicant. Has anything arisen that raises points anybody else wishes to ask? Okay. Can I just check where we're up to with documentation? Because I know some things were following through. And you raised a point this morning, Mr. Cameron, about delaying submission of I think the explanatory memorandum.
That's right.
In terms of consequences from the round table.
We will submit that, and I'll let Ms. Redmond tell you when.
I think it's already in, sir.
Well, I think I think so too.
Yes. And I think the other plans, if they've not yet been submitted, they are on their way.
Yes.
So that was the plans that were the associated plans that needed to be changed because of the national highways plots
Yes.
being removed.
But I suppose there's the outstanding point concerning if we have a schedule of drawings. Now, you're going to draft something along those lines, aren't you?
Yes, sir.
And do you want to draft that first and then consider where it would go?
Yes, we will draft it, and it will either be referenced in the certification article as a separate schedule, or we may just list them in that article itself. But I will take that away and see what's the most efficient way of dealing with it.
What we're concerned to ensure is that everything ties up and that there are no inconsistencies between different parts of the documentation.
Yes.
Yeah. So I know Mr. Cameron was keen to make sure that was done rapidly. Will you be in a position to advise us on that tomorrow morning?
Yes, I'm sure I will receive instructions from Ms. Redmond on it.
Yeah. Okay. Good. Just before we leave this, Mr. Cameron, anything, and Ms. Redmond, anything else you wish to raise on the draft order as proposed to be amended?
Not from me, sir.
Ms. Redmond?
No, sir. Thank you.
Okay. Thank you very much. Well, that concludes the second round table.
Why is it red light on?
Right, it's time. Sorry, Jeff. Go ahead. No, go on.
Sorry, the other thing. Right. Sorry, there's just a slight delay there. In terms of the programme, what we're now moving on to is closing submissions. What that means is that if anybody has anything else they'd like to say before we hear closing submissions, it's important that we hear them now because, as I'll say in a minute, closing submissions are not an opportunity to raise any new evidence. So just before we move on to that, then what we'll do is we'll hear closing submissions from those opposing the scheme, and then we'll hear closing submissions from the two local authorities, and then tomorrow we'll hear closing submissions from the applicant. Although just before we do that, we're giving the opportunity to the applicant tomorrow to make any points about written representations that have been made. So I can't see any hands up there. So just a brief reminder that the inquiry rules, which you might have heard being referred to before. Mr. Parker's got a microphone. Hang on.
Well, so I'm just conscious that you wanted my comments
of course,
on the document,
yes.
and I didn't want to.
No, thank you for reminding me. I made a note and I've ignored it. So yes, before we go on to closings.
Yes. So I'm grateful. So the document in question is CD 29/103, and you'll recall CPPF suggested that the inquiry should accept a journal article in relation to the efficacy of bat hopovers. That article has gone in without any submissions, as it were. I think it's listed as being a CPPF submission. I don't think there are any submissions from CPPF. It's just a journal article which went in at CD 29/102. The applicants provided comments at CD 29/103.
Yep.
We don't agree with all the what is said, but I'm not going to object on the substance to what is said by way of response to the journal article. I do object, and you will recall when I raised the issue that this document should not be an opportunity to do anything other than to respond to the specific journal article, which was concerned specifically with the efficacy of bat hopovers. And the reason we put it in is because it called into question the efficacy of bat hopovers. And as you recall, one of the issues is whether there is certainty or sufficient certainty of the efficacy of that form of mitigation. To cut to the quick, I say if you look in that note that paragraphs 2.4.6 and 2.4.7, which are right at the end, contravene what I said at the outset, in that they go beyond the scope of the efficacy of bat hopovers, and they seek to bolster the evidence given in relation to a completely different matter, that's to say the CPPF alternative. What is more, they seek to go behind what was an express acceptance by Ms. Reason in her cross-examination that the proposed vegetation removal that was required as part of the CPPF scheme would not be likely to lead to any significant effects on bats crossing over the road at that point. And these two paragraphs seek to go on that, to reintroduce that as an issue by referring to written evidence upon which I cross-examined Ms. Reason and which led to the concessions that she made. So if it hadn't been for 2.4.6 and 2.4.7, I would have said to you, we don't agree with everything, but I'm not going to object to its going in. If 2.4.6 and 7 were deleted, as it were, from the document, then so be it. But otherwise, I do object to those aspects of the document.
Mr. Henderson or Mr. Cameron?
Yeah, over to me. So when you look at 2.4.6, what it draws on is one of the findings in the study. That finding in the study is adverse to CPPF's case. Perfectly legitimate for us to draw that to your attention in responding to this document that they put in. It's unfortunate for them that it blows back against them, but it's perfectly legitimate for us to draw that to your attention, to explain its application to the CPPF scheme, i.e. it is adverse to their position. And in 2.4.7 explains that point further. It doesn't go back on anything Miss Reason said in cross-examination. You'll have to look at your notes. She gave caveated answers on this point. It's entirely consistent with the caveat she gave. So it simply arises because CPPF put this note in, it cuts back against them, and we've pointed that out. There's nothing more to it, and it's not improper.
Mr. Parker?
Well, it doesn't cut back against anything that CPPF said, because it's talking about canopy cover in relation to bat hopovers. Again, unfortunately, Mr. Henderson perpetuating the mistake that Ms. Reason made in her written evidence, which she then conceded, which is that the CPPF alternative wouldn't result in any reduction in canopy cover at a point where bats are likely to cross the road. There were 2 individual trees which were likely to be removed. And again, that just simply isn't relevant to what the journal article was about. Ms. Reason was cross-examined expressly on this topic and gave very clear answers and very clear conclusions, which this note seeks to go back on. In the words in the brackets, it is not the case that the CPPF scheme is preferable given this concern. That's a direct contradiction with the conclusions given by Ms. Reason in her evidence. And so it is just not appropriate to, as it were, revisit matters given in oral evidence in this way.
Mr. Henderson, in terms of the approach of the article, it was about bat hopovers, and was the reference to the canopies not in relation to mitigation in the form of bat hopovers? Yeah, no, that's. But I think that's the point you're making, isn't it?
So the CPPF want to put it in, evidence about trying to come around the roads. That's fine. We always said we'd let this in, we just respond to it. We shouldn't be curtailed to respond to only bits of the article that CPPF like and not the bits that they don't like. We should be allowed to respond as we have done to the entirety of the article.
But wasn't that wasn't the canopy cover point about canopy cover in the vicinity of a designed bat hopover, whereas I think isn't the point here about the existing overhanging canopy of parts of the SSI of Madingley Road?
So to the point in the article, so that applies to all canopy cover near roads. It's not delineated one way or the other.
I think we've heard what both sides says. I think we'll come back to you before CPPF have an opportunity to make their closing, because I think I do want to discuss this with Mr. Clegg a bit further. But I've heard what you said. Thank you. Is there anything else that we need to pick up before?
Not from me.
Closings. Just in terms of arrangements, it'd probably be helpful if people giving closings could maybe sit at that end table. Mr. Parker, if you finish with the microphone, would you mind moving to the?
Of course not.
Just to do that, because as I understand it, we've got parties who oppose the scheme who'll be sitting there, but then when it comes to the councils, they've already got a table. They're at an advantage there.
There's a lady standing at there's a chair there you can use at the front.
So yes, so just a reminder that the rules under which this inquiry is carried out requires anyone making a closing submission to also provide the inspectors with a written copy of the submission. As I mentioned, we'll first hear from interested parties who made representations against the scheme, and what we'll do is, because the inquiry rules make it clear that the applicant has the final right of reply, they'll be given that opportunity tomorrow. Mr. Cameron, is there something you wanted to add there?
What I was going to say was conventional that when delivering a closing submission, that a copy in writing is given to the opposing parties so that they can follow it.
Yes.
It may be that people have made that arrangement, but if they haven't, I don't want to delay matters. If it's sent to the programme officer and this is a big if, it goes immediately on the website or is sent to us, then we'll manage electronically. But that is trying to be helpful rather than saying, let's grind to a halt because somebody hasn't brought a written copy.
Yes, and this is also important. And again, the requirement to provide a written copy isn't an opportunity to change anything that might be in anyone's closing. It must be a copy of the submission that's been made.
Well, so I'm asking for it now.
Yes,
is what I'm.
Yeah.
So,
well, I'll be expecting each party to just confirm that, and if Miss Vincent's got copies that can be put up, that'd be helpful. Just to say that those those less familiar with the inquiry procedures, closing submissions, as I say, are an opportunity for parties to set out their case that's been made at the inquiry, but that covers evidence that's been both prepared in writing and orally. So it's not an opportunity to provide new evidence that has not been considered by the inquiry. It's not an opportunity to renege on any points that have either been accepted or conceded during cross-examination. And also, it's good to see a number of people here, but just a reminder that you'll be hearing from parties this afternoon who both oppose and support the proposal. This is still part of the formal process of the inquiry, so it's not appropriate for you to sort of show disagreement or approval by sort of clapping, booing, or making comments, please. And I've also found the acoustics in this room make it very easy to hear comments, so please no sort of whispering or making comments. So the first person I have on the list is Mr. Graham, who I understand is going to make comments on behalf of the Mayor of Cambridgeshire and Peterborough, Paul Bristow.
So while Mr. Graham is setting up, without repeating myself,
Yeah.
can we have it so we can follow while he goes through it? Thank you.
So, Mr. Graham, just on that, can I confirm that you have provided a copy of your closure?
Yes, I have. Yes.
And is that you provide an electronic copy rather than a hard copy?
I've literally just in the last few minutes provided a PDF copy. Yes. So.
And can I check to see if with Ms. Vincent whether that's been made available yet? Thank you. Yes, I can see that now. It's on the page of inquiry documents at the bottom. There's heading for closing statements, and hopefully other people who are planning to make closings this afternoon can provide those documents to Ms. Vincent so they can already be uploaded. So. Mr. Graham, over to you.
Thank you. The Mayor's opposition to the C2C busway was clear in his statement of evidence and his oral evidence to the inquiry. He believes this is an outmoded proposal which doesn't provide value for money. It doesn't fit with the direction that he is setting for local transport policies. Moreover, he can give no guarantee that the services envisioned for the busway by the applicant will be permitted to run under bus franchising. The Mayor leads to combined authority, which is the local transport authority. It is his authority which sets strategic transport policies for the region, not the applicant, nor the GCP. He is responsible for developing the new Greater Cambridge Transport Strategy. In his evidence, the Mayor was clear that he intends to proceed with bus franchising. The independent review on franchising implementation is examining the model that will be adopted, not whether to proceed. Bus franchising is therefore a dominant contextual fact when considering the application. Although the time frame for implementation is likely to shift from September 2027 to April 2028, bus franchising will happen, and it will happen before any C2C busway would be completed. It is the Mayor, and only the Mayor, who is responsible for creating a bus franchising scheme. This includes the specific bus routes that will operate across Cambridgeshire. These franchise routes, including routes from Cambourne to Cambridge, will already exist. So for new routes using the busway to be created, an operator would need to apply to the Mayor for a service permit. An additional route would need to satisfy conditions that he will set down. As he outlined in his evidence, two criteria in particular could present a problem for any service permit applications. The first is safety, given the non-physical guidance technology. The Mayor was clear that this would need to be proven technology, which is not the case at present. Even the existing busway with physical guidance has had considerable safety problems. The applicant has been subject to a £6 million fine and is currently constructing new fencing the length of the route. Unauthorised access has been an ongoing problem despite the concrete guide rail design. By contrast, the C2C design is in effect a road. Unauthorised access could be a far greater problem. The second criteria is competition. A new route cannot undermine the financial viability of the Mayor's franchise routes, including those from Cambourne to Cambridge. At this stage, those routes have not been specified. However, any service operating on the busway would obviously have an impact on other routes. At various points, the applicant and the GCP have sought to downplay the Mayor's powers relative to his board. This board includes the council leader of the applicant as a member. But service permit applications will be determined by the Mayor and the Mayor alone. It is far from clear that he could allow the busway to operate as intended. Even if safety concerns could be addressed and overcome, there is significant uncertainty about the frequency of any permitted services and the overall routes that they would follow. The applicant assumes that guided buses would continue from the busway to serve various locations in Cambridge. But one plausible outcome is that new bus services would only be permitted to operate on the busway itself between Stirling Road and Grange Road. Another is that even this would have an adverse effect on the Mayor's franchise routes and the busway would not be used at all. So there are good reasons to believe that the busway might be incompatible with the Mayor's approach to bus franchising. There is a second potential incompatibility with emerging local transport policy. The Mayor has been clear that he wishes to develop a light rail network for Cambridge. Through the Cambridge Growth Company, work has already begun with the Combined Authority on a mass rapid transit study funded by the DfT. This will be modelled in the Greater Cambridge Transport Strategy. As the Mayor noted in his evidence, a new busway is at odds with his ambition. It would not form part of light rail services and could also cost more to build than light rail tracks. A busway could only be converted to light rail at further significant cost. Although a busway is arguably compatible with the existing local transport and connectivity plan, which was produced by the Mayor's predecessor, the whole local framework is set to change. The English Devolution and Community Empowerment Bill will abolish the applicant and give the Mayor considerably enhanced powers, including in relation to the Combined Authorities Board. The applicant will no longer exist by April 2028. From that point, the board is likely to have just 2 constituent councils. All transport decisions will be taken on the basis of a simple majority vote, with the Mayor having both a casting vote and a veto. The local transport and connectivity plan will be able to be reviewed or replaced on the basis of those new voting arrangements from royal assent next summer rather than 2028. When he appeared at this inquiry, the Mayor indicated ways in which he disagreed with the plan and wished to alter it. As the Mayor also noted, from next summer he will be solely responsible for setting local transport policies. This includes sole responsibility for producing the Greater Cambridge Transport Strategy, which will model the different transport interventions across different growth scenarios using the updated CAPCAN model. That work, as he said, will take place over the next 9 months. There are 3 associated points. The first relates to modelling. The applicant, the GCP, the Combined Authority and the Cambridge Growth Company all agree that the updated CAPCAN model is the right one for assessing local transport changes and showing the interrelationships between different interventions. The Cambridge Growth Company also intends significant growth beyond the emerging local plan. How different interventions perform across the different growth scenarios will include the potential impact of East-West Rail on demand for bus services from Cambourne to Cambridge. So the Greater Cambridge Transport Strategy work may result in substantially different results to the modelling presented to this inquiry within months rather than years. The second relates to justification. The Greater Cambridge Transport Strategy may undermine the justification for the busway through the inclusion and testing of other transport interventions, including mass rapid transit solutions. And the third relates to local transport policy. A busway may be incompatible with the conclusions of the GCTS and the approach that it adopts. If the policy is to build a light rail network, it makes no sense to build a busway, which is difficult and expensive to convert, and it might be in the wrong place. Even without these points and the ways in which the busway may be incompatible with both bus franchising and new local transport policies, the Mayor believes that it will still offer poor value for money. It has a poor underlying BCR. As others have argued during this inquiry, development at Bourne Airfield should not be included in that calculation. As the Mayor noted, it is possible to change the Grampian condition in the Section 106 agreement. Indeed, altered transport patterns following the pandemic with lower road usage provide strong grounds for such a change. The airfield will still be being built out when East-West Rail is complete and taking passengers to Cambridge South and Cambridge at high speed. Beyond light rail and East-West Rail, immediate alternatives to the busway may also exist. It is unfortunate that for the purposes of the inquiry, such alternatives are subject to the same evidential tests as the busway proposal, when those proposing them lack the resources of the GCP and the applicant. The Combined Authority itself lacks the resources of the GCP in that respect. As the Mayor has only been in office for 6 months, it has not been possible for him to complete detailed feasibility work on on-road options. That process will begin with the Greater Cambridge Transport Strategy. Nevertheless, given a dual carriageway route to North Cambridge and other options for Madingley Road, the Mayor's belief is that such alternatives are plausible. The busway began as an unspecified mass rapid transit connection to a tunnel, which would form part of a Cambridge autonomous metro. Now, it would essentially serve West Cambridge if it ever took buses at all. Taking buses at reduced frequency and without the connectivity envisaged would make the cost unjustifiable and make maintenance costs difficult or impossible to recoup. And any bus that got beyond the end of the busway would find itself in the same traffic and congestion that still needs to be solved. C2C is a route to a tunnel that doesn't exist. And when a mass rapid transit network does begin, it won't connect. No one is actually enthusiastic about the busway. As the mayors argued, C2C supporters recognise the need to do something, and this is something. Because it has taken time to get to this stage, they feel obliged to keep going, rather than thinking again. The GCP feels obliged to keep going with busways because they are all that it has left before its time is up. But none of that makes this busway a good idea. None of that makes it provide value for money. None of that resolves the uncertainty around the modelling or the services it might take. In fact, given the safety concerns and the potential impact on franchise routes, it is possible that the busway could be constructed but never allowed to take a single passenger service. It could become a £200 million white elephant. The Mayor's entire approach to his office is to be pro-growth and pro-new transport infrastructure. The tragedy of the time and effort spent on this application is that a C2C busway won't help to get Cambridgeshire and Peterborough moving. He believes these plans should be rejected as uncertain, expensive, and backward.
Thank you, Mr. Graham. Hello, Ms. Casey. You're here on behalf of Coton Orchard and Houston Crest Properties Limited.
That's right.
If you'd like to make your, if you refresh it, it's there.
I've also got some hard copies if that makes it helpful.
How many have you got?
A couple. 2. But otherwise, I think it's on there.
We'll share one. Mr. Cameron can have the other one.
Spencer's been incredibly efficient. Ms. Spencer's been incredibly efficient because it's all on the website, so we're happy to work on that basis.
Thank you.
Okay, thank you. I want to begin by thanking those who have borne this Sisyphean struggle alongside us. Neighbours, volunteers, experts, our fellow residents of Cambridgeshire. Ordinary people who have been extraordinary. For the 10 years they have given up weekends with family, counted bats and moths at dawn and dusk, gathered data to lend weight to our words while introducing the next generation to the wonders of the natural world. They've taken time from work, juggled care and other commitments, and found the resolve to be here today. They've sat in this room day after day, submitting themselves with grace and courage to the cross-examination of the county's council. They're not paid professionals, not defendants, but members of the public who care enough to take part in this public inquiry. They've baked cakes and brewed tea, run stalls and sold crafts in the village hall to contribute to Cambridge past, present and future, and Coton Parish Council's £140,000 fighting fund to help pay for the barrister who speaks after me, representing those defending this landscape. While the county has spent over £2 million of public funds on lawyers before the inquiry had even begun. The balance is stark, but it only makes their efforts all the more admirable. They have come here and answered for what they did not cause, while those whose votes set this in motion, the county councillors, have yet to appear to defend their choice, to answer your questions, inspectors, or ours, the public they claim to serve. We have been told that this scheme is widely supported and that opposition comes only from a few local affected people. If that means those who have walked the route, who know the land, who have stood on the soil itself, not sat in an office far away drawing lines with no sense of what they cut through, then I am proud to be counted among them. However, the over 300 formal objectors, 14 environmental groups, and the 24,200 who have signed the CPPF petition, written to MPs, watched these proceedings from across the world, they are not a few. They are proof that conscience remains alive, articulate, and uncowed in Cambridgeshire and far beyond our borders. This inquiry has in many ways been about language, about the distance between what is said and what is meant. I should admit that I'm an accountant by training. I'm not a lawyer or witness or expert witness. This is my first experience of a public inquiry. I came here expecting to talk about how this scheme doesn't add up, to share my lived experience over 30 years walking Coton's footpaths, not to duel in adjectives or quibble over citations and my choice of editing tools. But even those of us better with numbers than words can tell when language is being made to carry more weight than truth will bear. We've been encouraged by the applicant to treat the words like need, growth, benefit, and sustainable as unquestioned virtues. But your task is to test whether these words match what is real, what you've seen and heard yourselves, and whether they survive the application of ordinary common sense. The county's opening claim that the planning balance is tilted firmly in favour of the scheme. It sounds authoritative, though perhaps that is easier to assert when the same hands have written both the policy and the proposal it endorses. When authorship and advocacy overlap, balance becomes less a matter of evidence and more a matter of design. When this inquiry began, the applicant spoke of near universal agreement that a guided busway was needed between Cambourne and Cambridge. No such consensus exists. There is agreement that public transport could and should be improved. But goodwill is not evidence, and it does not justify this route and this scheme. Cambourne already has regular bus services linking it to Cambridge, St Neots and beyond, as Miranda Fyfe demonstrated when she took buses across Cambridge to this inquiry. And Dr Sutton, who cycled into Cambourne from Cambridge, shown that active travel routes already exist and can be bolstered by schemes such as the Cambourne Greenway, already under construction. Could public transport be better? Of course. But the suggestion that Cambourne is cut off does not survive contact with the bus timetable, the road, or the lived experience of those who use them. After spending more than 18 million, the County Council has not evidenced where people actually want or need to go, or how this scheme would serve those journeys better than improvements to existing roads and services. Public transport should begin with people, not policy. The Mayor, as leader of the Combined Authority and therefore the Transport Authority, has made clear he cannot guarantee that any bus service will ever run on the proposed route. His duty is to meet the needs of the whole region, not one narrow corridor from a finite budget. Those limited resources should deliver the greatest public good, not be sunk into a single rigid corridor already covered by the Stagecoach 4 bus route, Whippet Coaches X3 and other existing services, while some communities across Cambridgeshire have none at all. Fiscal prudence is a lesson the county, as the accountable body for the GCP, might wish to revisit. Its projected budget deficit for 2025 to 26 has grown during the course of this inquiry alone, from 28 million to 34.2 million, and now to 40.3 million. The project's own economic case places the benefit cost ratio between 0.43 and 0.5. In plain terms, for every pound of public money invested, barely half is returned. While the City Deal grant may fund the initial infrastructure, any overspend, which experience suggests is all but guaranteed, will fall to the county, along with the long-term cost of maintaining it, 1.1 million per annum for infrastructure alone. The GCP's own budget now forecasts a cash flow deficit reaching 185 million by 2030-31, beyond the lifetime of the City Deal, and potentially beyond the lifetime of the applicant in its current form. The heaviest spending falls years before the income on which they rely. Bridging that gap would require borrowing that does not appear in the county's capital strategy, and Section 106 receipts cannot lawfully be used to service that debt. No alternative funding has been identified. And if the GCP's contingency is to go back to the Treasury, recent experience should give pause. Cambridge's wastewater treatment plan reallocation project lost its support after securing a consent order. A reminder that central funding is never guaranteed, especially when competing with new rail infrastructure such as the Cambridge East and the confirmed Cambourne station on East West Rail, both of which the government has repeatedly endorsed. Under the Transport and Works Act framework and the parallel principles governing compulsory purchase, the Secretary of State must be satisfied that a scheme is properly funded, financially prudent, and capable of delivery. On the figures before us, that assurance is not yet available. Viewed against the statutory framework in which this decision must be made, it is perhaps a curious moment to champion a project whose costs multiply as swiftly as its justification shrinks. These figures alone should stop the scheme in its tracks, though it is not clear that it has any. Whether curb-guided or optical, the order does not specify. There is no mention There is no mention in the Transport Works Act order or the planning statement of guidance mechanisms, only vague assurances in the transport assessment and the outline business case. It is intended that buses using the busway will be optical guided. It has been assumed that C2C will deliver an optical guidance system. For something called guided, it is remarkably without direction. The county is responsible for highways. The GCP is a delivery partnership. Neither has the power to run or franchise bus services. Bus services are only assumed by the applicant to be associated with the C2C scheme. If the applicant truly wishes to improve public transport, perhaps the most constructive step would be to repair the roads so the mayor can put buses on them, and to maintain the paths so that children can walk and cycle safely without needing to veer into danger. This is why joined-up thinking and joined-up transport are essential. The test is not whether we can pour concrete west of Cambridge, but whether we can connect people across it in ways that serve actual need rather than imagined. And while the applicant has drafted conditions that bar buses from operating between midnight and 6 a.m, it has given no clear account of how buses will proceed beyond Grange Road. Andy Campbell, former managing director of Stagecoach East, has publicly criticised the GCP route as fundamentally flawed. This route fails to provide direct access to Addenbrooke's Hospital, post-16 education in Cambridge, science parks to the north, or other key destinations such as the Cambridge Biomedical Campus and across the southern arc where the greatest concentration of jobs and growth lies. Matthew Baker, Cambridge resident and worker on the West Cambridge site, echoed this in his evidence to the inquiry, setting out turn by turn, street by street, the dangers and delays faced by buses trying to enter this already congested pinch point. Much of what we've heard from the applicant has been framed in the language of growth of jobs, housing, and the economy. Central government has called Cambridge the engine to drive economic growth across Britain. The question is not whether that ambition exists, but whether this scheme on this alignment genuinely supports it. Yet this route risks obstructing the very national infrastructure on which that growth depends. Under Madingley Hill lies land identified for the Madingley Service Reservoir, part of the strategic water supply works linked to the Fens Reservoir project, a nationally significant infrastructure project. The scheme allows for up to 30 million litres of treated water to be stored within a safeguarded zone of around 13 hectares. Recent consultation material indicates that additional land may be required for overflow infrastructure, including a pipeline to Bin Brook as a safety provision. While the precise route remains to be engineered, overflow from a service reservoir must follow the natural fall of land, placing this corridor in direct tension with the busway alignment. At the same time, the proposed C2C busway crosses the planned route of East-West Rail, on land that the Secretary of State has safeguarded for the new railway. Whether by bored tunnel or by cut-and-cover construction, the viability of the engineering decision has not yet been tested, and its outcome will dictate disruption across the C2C preferred scheme. I acknowledge that the overlay in my proof was basic, no more so, however, than the applicant's own route plans. Yet even a simple comparison with the Planning Inspectorate's published documents reveals clear spatial conflict. The applicant may say these matters can be resolved, but resolution here means redesign, delay, and cost. It does not mean compatibility. It is worth recalling that the Transport Works Act order for the C2C busway is a local initiative, promoted, led, and formally submitted by the County Council as Highways Authority. They seek this order because it is the only legal mechanism that grants in a single instrument the exceptional powers required: the compulsory acquisition of land and rights, the construction of permanent works such as new junctions, bridges, and underpasses, and the permanent extinguishment of private access and minor roads. What it is not is a nationally significant scheme. Instead, it is less than 8.5 miles of road that would have to bend around national water infrastructure, thread through future rail works, and carve through 4 wildlife sites, only to stop at a congested pinch point with little onward reach. We are also told that growth at Bourne Airfield is particularly dependent on C2C, that delivery beyond 500 dwellings is prohibited by a planning condition in advance of the busway's delivery. The next words, or equivalent provision, change everything. They mean that growth is not contingent on this guided busway, a public timetable service on existing roads, a bus lane. Any proportionate transport improvement would satisfy the condition. Additionally, the county, and in particular the district council as planning authority, already hold the power to vary, discharge, or satisfy the requirement themselves. They hold the key to their own lock. Yet instead of turning it, they have helped fashion a £200 million sledgehammer. Constraint, necessity, unlocking growth, repeated until the rhetoric begins to sound like fact. But when examined rather than echoed, the supposed barriers to growth fall away. The county insists that alternatives were adequately assessed. Yet the on-road option along the A1303 was never tested on equal terms. Those who travel the route know it already carries buses and cyclists, and that with modest and timely improvements, it could carry many more. A single bus lane, better signals, reliable service, achievable now, without destroying an ancient landscape. But once off-road became GCP doctrine, every later decision was shaped to defend it, not to question it. We must remember that this inquiry is not a debate about generalised transport ambitions or uncosted possibilities that may one day exist. It concerns the Transport and Works Act order before you, a defined legal instrument that authorises specific works starting in Cambourne and terminating on Grange Road. The most controversial section of this scheme is in fact a mere 1.6 miles. The stretch that leaves the highway at Madingley Mulsh and cuts through Madingley Hill Farms and Coton Orchard to require construction of a new M11 bridge. More than half of the total route lies on or within existing highway land. Yet it is this short off-road segment, the most destructive, least justified part of the scheme, that defines the whole. That is the scheme before the Secretary of State, not the CPPF's on-road alternative, which was never claimed as a fully engineered design, but offered as an illustration of what could be achieved if the county, as Highways Authority, were willing to consider it. It would be curious logic indeed if the existence of a more sensible idea became the excuse to impose one that makes no sense at all. Cambridgeshire County Council, the applicant, is the same authority that built the St Ives busway, a project that ran 65 million over budget, a near 60% overrun. It caused serious accidents, and the county was later condemned by Judge Mark Bishop as rigid and blinkered, earning the council, and by extension us the taxpayers, one of the largest fines ever imposed on a local authority for safety failings. It matters because the same authority now asks to be trusted again. The proposed route cuts across existing walking and cycling paths, including the new greenways and well-used desire lines, forcing people to cross fast-moving buses at multiple points, many with poor sightlines or steep gradients. Fencing, added as protection, will narrow verges and make visibility worse. These are not details, they are a matter of safety. The applicant assumes the risks can be managed later through signs and barriers. But that was exactly the attitude the court condemned. Safety cannot be bolted on afterwards. A design that creates new conflict between people and vehicles is not safe. It simply moves danger to where people already are. What happened to lessons learned? When the council voted to apply for this order, Lucy Nestinger, then deputy, now leader of Cambridgeshire County Council, justified felling hundreds of trees in Coton Orchard to move Cambridge to a net zero economy. That same environmental claim has been repeated to this inquiry, that the scheme will deliver a net reduction in carbon emissions. It is an extraordinary claim to destroy a living carbon sink in the name of carbon reduction. Professor Hurst, giving evidence for CPPF, concluded that the scheme would in fact be a net emitter of carbon. When the county's barrister pressed her to agree that if it was a good strategic fit with the local transport and connectivity plan, a document shaped with the involvement of many of the same local authorities promoting this scheme, she unsurprisingly disagreed, saying, "If something is a net emitter, it's implicit that you are emitting more carbon than you would have done had you done nothing." That exchange distills the central flaw in the applicant's case, the manipulation of words to fit the argument, rather than let facts speak for themselves. If low carbon can describe a net carbon emitter, the language itself has lost its integrity and takes us all for fools. The applicant describes Coton Orchard as a recently designated county wildlife site, whose trees are of more recent origin. It is another careful contortion of language to suit an agenda. The designation may be new, but the habitat it recognises is not, a living mosaic shaped over decades. All trees planted after the first Bramleys are by definition of more recent origin, yet most have stood for half a century or more. The orchard holds hundreds of recorded species: bats, birds, invertebrates, fungi, mosses, lichen, including many nationally rare or scarce. It is a traditional orchard, a UK Biodiversity Action Plan priority habitat, one of the largest in Cambridgeshire. Only the applicant's paid experts dispute this. Tape measures and checklists in hand, they search for the one technicality that might let them say it is something less. But against them stands every independent authority who has looked without an agenda. DEFRA, Natural England, the People's Trust for Endangered Species, the Orchard Network, Wildlife Trust, and the county's Wildlife Site Panel, a multi-agency group of ecologists, councils, including the applicant, district and city councils, recorders and specialists who unanimously designated it as a county wildlife site in the category traditional orchard. On one side, a hired effort to unpick a definition. On the other, the settled judgment of those whose job it is to know. The applicant says that adverse impacts have been identified and mitigated, yet its own ecology report accepts that even taking into account of that mitigation, the loss within the Coton Orchard County Wildlife Site would remain significant at a county scale. That is their evidence, not ours. Under the NPPF, the development that causes the loss or deterioration of irreplaceable habitats, including veteran trees, should be refused unless there are wholly exceptional reasons and a suitable compensation strategy exists. Here, neither requirement is met. Within the order, deterioration of veteran trees is certain. Within the order limit stand 6 veteran bramleys. The applicant proposes to protect 3 and to move the other 3. But a veteran tree cannot be dug, dragged, or replanted without deterioration. Its survival depends on mycorrhizal networks, soil structure, and hydrology formed over many decades. The moment translocation is proposed, the NPPF test is triggered. Deterioration is inevitable. There are no wholly exceptional reasons. This is a local bus scheme, already served by existing routes, and it does not reach the Cambridge Biomedical Campus or South Cambridge, where the greatest demand lies. It is not a nationally significant infrastructure project. Nothing in this inquiry approaches this threshold of wholly exceptional reasons. There is no suitable compensation strategy. Planting young trees and tending them until they are veteran is not compensation, it's a half-century prospectus. A sapling cannot replace hollow limbs, cavities, fungal webs, or seasonal food plants relied upon by the species present today. Nor do BNG credits at Lower Valley Farm, 1.25 million in off-the-shelf units, transferred in effect from county to itself, recreate a century-old orchard mosaic. A credit replaces a metric, not a habitat. The mitigation program cannot be delivered. The applicant's veteran tree timetable, root prune autumn 2025, root prune autumn 2026, translocate autumn 2027, 10 years of aftercare, cannot occur within the years it names. This inquiry runs to November 2025. The Secretary of State's decision follows months later. Until a Transport Works Act order is confirmed and the CPO powers are in force, the applicant has no lawful access to land. As I put to Mr. Alder, root pruning cannot begin in 2025. In reality, the earliest conceivable start is 2026, or more likely 2027, pushing any translocation into 2028 or 29. A mitigation plan that begins the year it claims to finish is undeliverable within the stated timescale. The county claims that those who live closest have the loudest concerns. Naturally, because we are the ones who see most clearly what stands to be lost. Those who live beside a landscape understand its value not in theory, but in the daily rhythm of their lives. In the sound of birds returning in the seasons of blossom and fall, we notice the small absences first and understand what they mean. Sapatha Dasgupta on natural capital. Persistent incremental encroachment into nature is insidious because each move seems near harmless. A new bus lane cutting into an ancient orchard here. A bat habitat destroyed to make for additional housing in an urban sprawl elsewhere. The orchard will not return, and the bat population will die because it has nowhere to go. When an ecosystem is fragmented into parts, the supply of its services declines. The sum of the parts gives less than the whole. Nature's accounts do not balance once its assets are written off. And that is what this order would do. Spend an orchard, fragment a habitat, divide a living system. This inquiry is not simply about a busway. It is about what we choose to count as value. What is at stake is not simply the loss of trees, but the loss of perspective, a failure to see that the living world has worth. So I end where I began, with Coton Orchard. Since 1950, England has lost more than 90% of its traditional orchards. What survives now are the last fragments of a once common patchwork across our countryside, one that sustains some of our nation's now most endangered species. Coton Orchard has endured for more than a century through war, drought, frost, and change. It asks only to continue doing what it has always done: shelter life, feed the soil, hold its place in the story of this landscape. It asks only to go on living. The county opened this inquiry declaring that the planning balance is tilted in favour of the scheme. After 8 weeks of evidence, even with a thumb pressed firmly on that scale, the weight of fact has begun to right it. The need is unproven. The barrier to growth is self-made. Reasonable alternatives were not fairly or proportionately considered. The guidance system is undefined. The technology remains untested in open countryside. The carbon case fails its own arithmetic. The public cost outweighs any claimed public benefit. The funding is not secured. The habitat is irreplaceable. There are no wholly exceptional reasons for the scheme. There is no compelling case in the public interest. And the figures, financial and environmental, simply do not add up. We are each of us custodians of this shared earth for only a moment in time. The choices we make decide what remains for those who follow. This moment was mine. I've done my best to defend Coton Orchard, the ancient trees that preside over its unploughed grasses, the birds that feed upon its apples, the people who have loved it in the past and who love it still. I can only hope I was enough, that we were enough. Inspectors, whether Madingley Hill Farms, the orchard, and all that it sustains endure beyond this moment now rests in your hands. Thank you.
Thank you.
Ms. Gazer, just one query that I have. Right at the end of your closing submissions on page 15, I'm not sure that it's. I'll check my notes and the evidence, but I'm not sure it's accurate that when you say the funding is not secured.
Right.
So, should we do this?
Yes.
Right.
Yes, exactly.
It's got 2 hours now.
Yeah. Yeah.
So I didn't interrupt at all, but you will have noted that there are new documents referred to, new images and the like in Ms. Gaisley's closing. We'll respond as best as we can in closing. But it's disappointing with the guidance you've given. And I know people are not used to these proceedings, but I do just note that point.
Yes, but I think our attention during closing was on the closing submission itself, rather than checking all the footnotes. I noticed there are quite a number, but without going to references, I couldn't be certain whether they're in or not. But I know what you said, Mr. Captain.
Good afternoon, Mr. Sadler. You're here on behalf of J&WR Sadler. And again, just in terms of copies of things.
We are submitting
Thank you.
these yesterday afternoon, so you should all have a copy, and I've got 3 hard copies if you don't.
I've certainly got a copy on the screen here. A hard copy is always helpful if you're willing to share one. Thank you very much.
If you're offering it all, thank you very much.
So over to you, Mr. Sadler.
Thank you. Pour some water. There was strength there. Thank you, inspectors. My family has never opposed the principle of improving public transport between Cambourne and Cambourne. We fully support better access to education and employment. We cannot support a scheme that causes unnecessary environmental harm, fails to deliver its stated purpose, and has been advanced without proper and meaningful engagement with those directly affected. At the preliminary meeting for this inquiry, I raised my concerns that proper procedures had not been followed in the lead up to these proceedings. Through the course of this inquiry, from the applicant's own witnessing,
advance or requiring access for the dig. Once proper communication occurred with Mr. Camp, the outcome was constructive. The route remained on the existing bridleway. No unnecessary greenbelt land was taken, and public cost was avoided, including the intrusive dig. This demonstrates something the applicant should have learned long ago. When landowners are treated fairly and engaged properly, better, cheaper, and far less harmful solutions emerge. Although the Greenway scheme is not before this inquiry, the pattern is identical to C2C. Where the route is easy, the applicant keeps to the existing corridor. Where it becomes difficult, it diverts off onto private land, even where there is an established route and remains viable. Exactly the same pattern has occurred with the busway. When the A1303 becomes constrained, instead of working within the highways and with landowners, the applicant diverts off into the greenbelt. The optics are identical and difficult to understand why this matter was then later used in cross-examination to discredit me. Engagement and the reliability of the applicant's record. The applicant's own correspondence confirms, before April 2024, there were only 2 informal visits to the farm. No minutes, no agendas, no structured discussion, and no attempt to understand operational or personal needs that can be provided by the applicant. The route alignment was fixed in March 23, and the applicant has admitted that no meaningful realignment could be considered after that point. Consultation, therefore, took place only after key decisions had already been made. This raises a fundamental question. Was CBRE, the land agents for the council, aware of this design freeze at the first formal meeting in April 2024? If they were, failing to disclose this was misleading. If they were not, the engagement process was flawed. What is clear is that by the 10th of April 24, CBRE were fully aware, as they were copied into correspondence expressly confirming the design freeze. No early formal notification letter was ever issued to explain the scheme, the statutory process, or the landowner's rights. This statement was not challenged by the applicant during cross-examination. The applicant claimed in writing that the public exhibitions between 2015 and 21 were an adequate substitute for direct engagement with landowners. They are not. Public exhibitions or general consultations cannot replace proper formal dialogue with those whose land is subject to compulsory acquisition. And this too has not been challenged by the applicant during this inquiry. The reliability of the applicant's official records is also in doubt. The applicant's record of engagement dated July 25 included an entry claiming that I emailed on the 7th of September 2023 to say I would act for my family. No such email exists. The applicant has accepted this was a complete false entry. This brings me to one of the most serious issues in this inquiry: fabricated evidence. During questions on the 12th of November, Mr. Cambourne put directly to the applicant's witness, Mr. Franklin of CBRE, the following log entry from the CBRE submission. Heads of terms and valuation shared with Bidwells, including draft agreements for both freehold and tenanted land, dated 22nd of February 2022. Mr. Cambourne asked Mr. Franklin, were heads of terms sent on that date? Mr. Franklin replied, no. He was then asked whether they were sent in May 2022. Again, no from Mr. Franklin. When pressed on when heads of terms were in fact issued, Mr. Franklin first suggested August 24, but the answer was not clear. He then immediately changed his answer to the 31st of October 2024, 2 weeks before the orders were served. This is not a typo. It is not an administrative slip. It is a completely fabricated log entry on the single most important indicator of meaningful negotiation. As I wrote in my proof of evidence, the applicant's record of engagement is not a record at all. It is an attempt to rewrite history. The CBRE log also includes an entry from the 1st of August 2023, in which a Henry Church of CBRE writes to someone called Samuel, apologising for not finding him a job in New Zealand. What possible relevance could this have to the C2C scheme? It reflects a culture of carelessness with public money. When I was cross-examined, Mr. Cambourne pressed me repeatedly about the fabricated entry by CBRE, asking several times whether I was saying it was incorrect. At the time, I reserved judgment because I had never seen these heads of terms. And, crucially, this supposed 2022 entry does not appear anywhere in the applicant's own July 25 record of engagement. I could not understand how this entry could be right. During his questions to me, Mr. Cambourne and I had a brief, courteous exchange about the importance of referencing the precise parts of case law in a proof of evidence document, and I readily accepted the advice. In the same constructive spirit, one would expect that the evidential material behind such a significant log entry would have been checked before it was put to me so firmly during my cross-examination. The fabricated entry attempted two things: to create the appearance of early negotiation and to imply that Bidwells acted as our representatives. Both are categorically false. Bidwells were engaged only for isolated work during the Bidwells are engaged only for isolated survey work, and the CBRE log confirms this. I would like to acknowledge that when Mr. Franklin gave his oral statement, Mr. Cambourne dealt with the issue directly and professionally, ensuring the full facts were presented, and for that I am genuinely grateful. However, during oral evidence, Mr. Franklin attempted to present a picture of constructive dialogue. With respect, that account does not align with the documented evidence or with reality. Having already acknowledged that his own engagement log contains a fabricated entry on a matter of fundamental importance, one might reasonably have expected the remainder of his evidence to proceed with caution. Instead, significant parts of his oral account continue to diverge from the factual record in ways that simply cannot be reconciled with what actually occurred. It is difficult to place any weight on his wider evidence. I could take this inquiry through each inconsistency point by point, but I'm only limited to 20 minutes. CBRE's lack of continuity. I would also note that I have never met Mr. Franklin. I've never spoken to him, and I've never corresponded with him. From April 24 through to the making of the orders, just 6 months, I have dealt with Mr. Henry Church, Mr. William Gullett, and someone called Mr. Brandon O'Connor. There was no continuity, no coherent engagement strategy, and this too undermines any suggestion of ongoing dialogue. And the disparity becomes even more stark when one compares our engagement log with those of institutional landowners, including colleges and the university. I do not need to set out the detail. A simple like-for-like comparison of the applicant's logs speaks for itself, and I invite the inspectors to consider that comparison if they deem appropriate. The human reality. My elderly parents have lived under the pressure for more than 10 years. They were never given proper meetings, never given clear information, and never given meaningful engagement. In one encounter with the applicant's survey team, my father, who is now close to 80, was told he should start investing in flying tractors. Our family farm is surrounded by land owned by the University of Cambridge, the same university that sits on the GCP board, and yet it is we who are most directly and severely affected. Whether intentional or not, the effect has been the same. J and W.R. Sadler were left out, ignored, and denied the early and meaningful engagement the law requires. The burial site. The burial site is one of the most distressing examples of how this scheme has been approached. My grandparents, Frank and Eileen Sadler, chose that spot in 1992 because, in my grandfather's words to me, it had the best views on the farm. The idea that this resting place might fall inside the boundary of a major infrastructure project could have been unthinkable to him at the time. From April 24 onwards, I raised the issue repeatedly, and each time I was told by Mr. Baker, the ashes are not within the busway. Yet, on the 26th of July 24, when the applicant finally marked out the 45-metre working width, it became clear the ashes lay 7 metres inside the compulsory acquisition boundary. Why this marking could not have been done months or even years earlier remains unexplained. When challenged, Mr. Baker said, and subsequently wrote, when he said not within the busway, he meant only the 7.4 metre tarmac strip. To my parents, that explanation felt deeply disingenuous. It reduces a matter of personal significance to a technicality and ignores the reality of a 45-metre construction corridor being compulsory acquired. The applicant later suggested the ashes could be left just outside the operational boundary, but the only reason the burial site is in jeopardy at all is because the applicant chose to drive a 45-metre wide transport corridor through the centre of a working farm, where it does not need to be, and so without meaningful engagement. Moving the boundary line by 1 metre away from the burial site does not resolve the issue. This is simply not how a public authority should treat those whose land and family history lie directly in the path of its decisions. Under Section 149 of the Equalities Act 2010, the applicant had a duty to engage with a disabled landowner. No such consultation ever took place, and the applicant has not challenged this point at any stage during this inquiry. Taken together, the fabricated records, the lack of any records of meetings before April 24, the mishandled burial site, and the complete absence of disability engagement, it is clear, and there has been no meaningful negotiation or engagement before the applicant sought compulsory purchase. Direct impacts and foreseeable safety risks. The proposed busway would sever our farm across a route used daily by children, staff, machinery, and my disabled mother. Up to 20 to 30 movements occur at this point on a typical day. This operational reality has never been acknowledged by the applicant or challenged at any point during this inquiry. The section between Cambridge Road and Cambourne Long Road is over 2 kilometres long, dead straight, unfenced, unlit, and without intersections. Similar design conditions on existing guided busways have resulted in repeated vehicle intrusions, including joyriders accessing the track, stolen vehicles driven along it, and fatal accidents. These incidents were serious enough for the County Council itself to be prosecuted by the Health and Safety Executive. This is not a speculative concern. It is a foreseeable risk, creating another isolated, unprotected, high-speed corridor that will inevitably create problems and greater risk. And if, or more realistically, when an incident occurs on this section, I will almost certainly be the first responder to any accident because of the lines that run through our farm. The County Council, as promoter and designer of the scheme, cannot later claim it was unaware of these risks. They are now set out clearly, publicly, and on the record on this inquiry. Scotland Farm Park and Ride. We have heard from a senior planning officer for the applicant that he frequently drives to Madingley Road Park and Ride and cycles the last 6 minutes into Cambridge City. I make that journey myself on a daily basis. Are we seriously to assume that he or anyone else will instead drive to Scotland Farm and then cycle 30 minutes into the city and 40 minutes uphill on the return journey? The applicant has not explained who will use Scotland Farm Park and Ride when it becomes operational. The existing Northern Corridor. The public has already funded a fast, reliable and direct transport spine. The 1.5 billion A428/A14 upgrade and the guided busway from Orchard Park serving Cambridge Regional College, Cambridge Science Park and Cambridge North, with links to Central and soon Cambridge South at the Biomedical Campus. This corridor is already operational today, faster and providing more certain journey times than the proposed C2C. It also delivers on the promise of access to education and employment, whereas C2C does not. Yet it has been largely absent from the applicant's case. The applicant has produced no travel to work evidence showing commuter flows from Cambourne to West Cambridge site. It has been mentioned during this inquiry by the applicant's own witnesses that the university has recently spent over £500 million on the West Cambridge site, and this includes the Cavendish and Whittle laboratories. But this goes to the heart of my argument. That investment has delivered academic and research facilities and not commercial office space for third-party tenants. The West Cambridge site is not and will never be a conventional business park. Furthermore, the University Master Plan now provides for over 5,500 homes at Eddington, half of which are key worker housing for university staff, directly reducing commuting needs. Eddington also includes large postgraduate accommodation blocks, further reducing external demand. This is central to the university's own strategy for the city. In short, the West Cambridge site is being planned in a way that reduces external commuting and directly undermines the applicant's claim of unmet demand from Cambourne. The CPPF alignment and St John's College. I have previously offered a narrow strip of land along the A1303 to facilitate the CPPF on-road alignment, particularly opposite Madingley Wood, if it is required. St John's College also owned land opposite the wood, and Mr Cameron was correct to point out that I cannot speak for the college, but the real-world choice is obvious for the college. A 45-metre corridor completely severing the land they own, or a minimal boundary strip that may or may not be required under the CPPF section and verge land that the college is probably unaware that it even owns. Any responsible landowner would choose the latter. The American Cemetery. A carefully designed pedestrian and cycle route past the cemetery entrance would strengthen its role as a place of reflection and learning. It is worth noting the cemetery already receives buses on a site safely and without difficulty, pulling into the grounds every 10 to 15 minutes, and this includes the Cambridge open-top tourist bus. As confirmed to Mr Cameron, I am not a heritage expert, and nor is Squadron Leader Colin Bell or Randolph Churchill in the true planning sense, but both recognise the quiet value that such a route could bring, as I mentioned in my oral statement. Their views reflect the cemetery's enduring purpose of remembrance, education, and connections between generations. Returning to the core question, I expect the applicant in closing will urge you to disregard the CPPF sectional proposal on grounds of insufficient detail. Yet to me, I have seen far more detail with the CPPF proposal than with the applicant's own proposal. They will, I'm sure, go on to say that we cannot wait for the CPPF scheme to be built. Yet I have not heard any credible evidence from a chartered civil engineer or a principal Tier 1 contractor to support this claim. What we have heard is opinion intended to create pressure to accept a flawed scheme, and by that I mean the applicant's scheme. The applicant's position, stripped of its presentation, amounts to this: even though our scheme is flawed, environmentally harmful, and clearly not supported by proper consultation, you must approve it because we have no plan B. But an on-road solution for the short 1.6 kilometre section, combined with the use of the northern corridor, is entirely feasible. I also want to place on the record, because our family owns land along the A1303, we would willingly make temporary construction compound space available. This would materially reduce the construction period and minimise disruption. The obstacles the applicant claims are insurmountable are, in reality, perfectly manageable through cooperation and competent planning. There is a saying, you do not have to accept a bad option simply because someone tells you it's the only option, and that is precisely where we are today. The conduct of consultation. Before turning to my closing, I want to address a final point in anticipation of the applicant's submissions. They may argue that the errors in their engagement record are minor, that the fabricated entries are less than important, or that the shortcomings in consultation can be excused by the scale or history of the project. With respect, none of that is compatible with the statutory framework. The duty to make reasonable efforts to acquire land by agreement, the duty to maintain accurate records of engagement, and the duty to consult a disabled landowner are not optional, and they are certainly not retrospective. The most serious fabricated entry asserting that heads of terms were issued when they were not sits at the centre of the applicant's claim of early engagement. A process that records negotiations that never occurred cannot satisfy the requirement for reasonable efforts for seeking compulsory purchase powers. And given how firmly that entry was put to me in cross-examination, I think it is only fair to observe that all parties are entitled to expect that key evidential material has been properly checked before it is relied upon. These are not procedural oversights. These are structural failings. The rules require that reasonable efforts be made to acquire land by agreement before seeking compulsory purchase powers. The evidence before this inquiry, including the applicant's own documents, sworn admissions of its witnesses, and the absence of any meaningful engagement, show that this statutory requirement has not been met. Sirs, the evidence before you shows that the scheme proposed by the applicant is not the right one. Thank you.
Mr. Sadler, on a number of occasions you've made reference to fabrication of statements from the applicants. It's a fairly serious charge, and whilst there clearly appear to have been mistakes that came out in questions, I cannot be certain of the reason for them. So I do treat that use of that word with caution, as you put it to us. The other point I just wanted to refer to was on page 4 of your closing, when you referring to the applicant marking out the full 45-metre working width. When we made our accompanied site visit to your property the other day, what was identified for us, where the markers were across the land, was an area that you'd marked out and that the applicant didn't necessarily dispute, but didn't necessarily agree with either.
So we can I reply to the question? So when we met, if you remember, we walked to the ditch, which is where the burial site was. That was the point that the applicant marked out the width. So what I said that I'd marked the canes in that direction and in that direction, but at the point that we stood at the burial site, that was the accurate width.
The applicant, you're saying the applicant did mark things out.
They marked.
I just wanted to check that.
Mark that, and then I gave Mr. Baker, the opportunity to either agree that or not, and he said yes. It was. That's exactly where they measured it. So at that point where we stood, that was the accurate measurement.
Thank you. Right. No, I just want. Yes.
Mr. Parker, we're just about to take a break, I think. So, it's 4:45. We'll take quarter an hour, and we'll resume at 4 o'clock.
Sorry, just before we take a break, I'm going to have to leave, I'm afraid, shortly after 5. And I think Mr. Parker will need an hour to read closing. So would it be possible for the council's closing to be read tomorrow morning? I don't anticipate it being more than about 45 minutes. But yeah, I won't be able to stay late this evening.
Yep. How long is your closing going to be, Mr. Cameron? I think originally you were saying it's going to be a day.
Yes, well, that's the current estimate, sir.
Mr. Cameron, can you translate a day into an approximate number of hours? It's fairly crucial for us towards the end of the Friday.
Yes, no, I appreciate that. So we're going to have to respond to some of the points made today, which we'll add. And we're over 100 pages already.
Yes.
And at 20 pages now, that's about 5 hours. And we'll probably be at about 120.
6 hours.
However, sir, we're mindful of everybody's arrangements, and it may be that because we come last, we don't have to read out every single word. It's not that we don't rely on them, but we may not read out every single word, and that should be able to accommodate Ms. Trabkin Writer coming tomorrow morning.
Okay.
I should also say, I don't know whether it's appropriate, but I have no objection if Ms. Trabkin Writer wants to go before me. But I appreciate that would be unconventional.
Well, I think since Ms. Trabkin Writer's supporting the proposal, I think it would be more appropriate that we hear that closing after yours. So I'm grateful for what you said there, Mr. Cameron. Obviously, if you're not available today, then and I'm conscious of the time, so I think if we do proceed on that basis, that we'll hear the two councils' closings tomorrow. Just in terms of timing, I think the agenda, well, the one I'm looking at doesn't have a time on, so that's an old one. Obviously, we're planning to start at 9:30.
Yeah, it might be earlier.
Yeah, I mean, I don't know. Obviously, starting earlier than 9:30 does cause problems with travel and things, but given it's the last day, and I'm conscious of how much time Mr. Cameron is going to need, whether a 9 o'clock start would be acceptable or appropriate.
Sorry, that's not going to be possible for me because I have a commitment in London this evening, and it's already a very early start to get here at 9:30.
Okay.
So I think 9 would be difficult. Sorry.
Well, in that case, I think what we'll say is we'll hear from the councils at 9:30 to tomorrow morning. In that case,
thank you.
Thank you.
John.
And we'll resume at 4:05 now.
Yeah.
Thank you. it's 6 minutes past 4. It's time for the inquiry to resume. And just before we do, I said that myself and Mr. Clegg would have have a word about the discussion there was in terms of what Mr. Parker had raised about the note that the applicants had provided about the academic article you put in. I think Mr. Parker, just looking at paragraph 2.4.6 of the applicant's note, because you objected particularly to these last two. I mean, I acknowledge you did mention there were some of the things you didn't agree with, but it was these two paragraphs you were concerned about. The first sentence of that paragraph 2.4.6, I think that just isn't that just a factual comment about what the study advises. So I think that's just reporting what the study advises. However, Ms. Henderson, I think paragraph 2.4.7 does seem to deal with issues that have already been addressed, and it does seem to go a bit further than just commenting on the particular particular issue in that publication. So I think from what we've seen, I think we'd suggest that paragraph 2.4.6 would be acceptable. But I think paragraph 2.4.7, I think in terms of Mr. Parker's concerns, I think that does actually sort of go beyond the commentary that was expected. I don't know if there's anything you want to.
I hear what you say. You've heard my submissions. If that's where you want to take it, then we'll reissue it with move in 2.4.7. If that would deal with the point that you've just raised.
I think. I mean, whilst that might not address all Mr. Parker's concerns, I think that paragraph seems to be the one that.
That's fine. Well, I'll ask that that's reissued overnight, so you have a replacement version in the morning.
Thank you, Mr. Parker. Is there anything you want to?
You've made your decision, and I accept that.
Thank you. Okay. Right. Okay. In that case, Mr. Parker, I'll ask you to make any closing submissions.
Thank you. There should be I've circulated a version to Mr. Vincent, so hopefully that's made to the website. I do have hard copies as well, if you'd appreciate.
Yes. Yes, that's always helpful. Thank you.
There should be enough.
Thank you very much.
Thank you. It's come up on the website, so thank you very much to Programme Officer.
Thank you. As set out in opening, CPPF and CPC acknowledges and agrees that there is a need to meet the objectives set for the scheme, to improve accessibility in the Greater Cambridge region, to support economic growth, to deliver a sustainable public transport service between Cambourne and Cambridge, and to improve the quality of life within surrounding areas. CPPF and CPC is firmly of the view, however, that the scheme that is the subject of the order and that has been put forward to meet those objectives has not, on the evidence that is before the inspectors and the Secretary of State, been justified. CPPF's concerns about the scheme are rooted in the applicant's proposal to construct an offline busway between the Madingley Marsh roundabout and Grange Road on the western side of Cambridge. That proposal is of considerable concern because, first, it will involve the compulsory purchase of land, including land owned by CPPF as part of its charitable purposes and held for the specific purpose of protecting the setting of the historic village of Coton and the countryside setting of Cambridge, and it will cause significant ecological harm, as well as harm to the landscape, the greenbelt, and other environmental harms. Given that the scheme involves the need for compulsory purchase, there must be a compelling case in the public interest. Given that the scheme is acknowledged by the applicant to cause ecological harms up to county level and will cause obvious harm to the openness of the greenbelt, there must be very special circumstances to justify it. CPPF is firmly of the view that such justification is lacking. As part of its evidence, CPPF has demonstrated that there is an alternative to the offline busway which would, subject to refinement through detailed design, as would be expected for any scheme of this nature, be effective in meeting the objectives of the scheme, be feasible in engineering terms, be safe, cause substantially less harm to ecological receptors than the scheme, preserve the significance of heritage assets, be in compliance with relevant development plan policy, be less harmful in greenbelt and landscape and visual terms, deliver upon the objectives for the scheme, be significantly less costly, and be deliverable in a comparable timeframe to the scheme and aligned with the build-out of the development at Bourne Airfield. CPPF relies upon the evidence given by Mr. Littlewood, Mr. Johnson, Mr. Lee, Mr. Woodfield, and Professor Hurst through their proofs of evidence and rebuttal proofs and their oral evidence to the inquiry, and this closing should be read alongside that evidence. I turn then to the first topic, claimed transport benefits. It goes without saying that in order to be satisfied that the order should be made, the Secretary of State must be able to understand what the transport benefits of the scheme are and be satisfied that those benefits have been robustly demonstrated so as to justify the compulsory purchase of land and incursion into the Greenbelt. It is important to bear in mind that although the scheme would involve the delivery of new physical infrastructure, the purpose of that infrastructure is simply to enable the operation of an improved bus service by comparison with the service that could be operated on the existing road network. The scheme and all the environmental harms associated with it can only be justified if, in fact, it would fulfill that purpose. Without that justification, the scheme is, to all intents and purposes, pointless. It is striking, therefore, that the applicant has spent so little of its time or energy at the inquiry trying to persuade the Secretary of State that the scheme will in fact deliver the transport benefits which are claimed on its behalf. Rather, the applicant has sought to focus the inquiry's attention on the claimed economic benefits of the scheme, principally through the delivery of housing, and on its importance to the delivery of objectives and policies in the extant local plan and now emerging local plan. It is important not to lose sight, however, of the fact that those policy objectives and requirements and the conditions and planning obligations attached to the planning permissions for development that is said to be unlocked by the scheme are all premised on the scheme delivering material transport benefits. After all, a public transport scheme that satisfies a planning condition but fails to deliver material transport benefits is unjustifiable in transport and planning terms. The transport benefits for the buses claimed for the buses using the scheme are that the scheme will provide a reduction in journey times for commuters travelling from Cambourne to Cambridge in the morning peak by 16 minutes, facilitate 8,800 additional daily bus passengers, and improve bus service punctuality. These claimed benefits all depend on a comparative analysis between the bus service facilitated by the due minimum infrastructure and the services facilitated by the busway using a transport model called the Cambridge sub-regional model. Subject to what the applicant has described as sensitivity testing, which is addressed below, the claimed transport benefits depend on analysis undertaken using the E-Series and F-Series versions of the CSRM. The E-Series model was released in 2019 using a 2015 present year validation and was used by the applicant to determine bus patronage. The F-Series was released in 2021 using a 2019 present year validation and was used to determine vehicle journey times. Both series suffer from obvious and fundamental limitations. Based on census data from 2011 and traffic counts taken in 2015 and 2019, they do not account for the fundamental change in travel patterns which occurred after 2019, consequent to the COVID-19 pandemic. The F-Series model forecasting report itself makes clear that even the 2019 validation year on which the F-Series is based was only added to extend the life of the model until such time as a whole new base year can be created once the disruption to travel behaviour and patterns caused by the pandemic has settled to a new normal state. The shortcomings in the CSRM have been identified in a report produced for the relevant transport authority, which also recognised that it would, by 2023, be possible to collect data representative of the post-COVID period. The government has made its position clear in respect of the need to account for the after effects of the COVID-19 pandemic in transport assessments in its TAG guidance. I won't read out the entirety of the guidance, but the COVID-19, it provides that the COVID-19 pandemic has had a significant impact on the pattern and volume of travel. And then moving down, it is the department's view and recommendation that this evident suppression of travel demand relative to a pre-pandemic projection of demand at this time should be appropriately represented in transport analysis, particularly in appraisal and analysis supporting transport investment decisions. Mr. Whitehouse, for the applicant, agreed in cross-examination, and it is obvious in any event, that any analysis based solely on the F-Series CSRM is not capable of representing that evident suppression of travel demand, given that it is based entirely on pre-COVID data. As noted above, the applicant has sought to account for the effects on travel demand of COVID-19 by reference to a sensitivity test published in July 2025. The extent of that test, however, is merely to assess the effect of 10% fewer cars and light goods vehicles on the network. Such an assessment fails to comply with the TAG guidance and is a wholly inadequate basis for carrying out the transport analysis which is necessary for a scheme of this nature. In particular, TAG guidance, the TAG provides prescriptive guidance as to how to account for the effects of the pandemic on travel demand. It provides that to account for COVID-19 related changes, trip matrices based before the beginning of the pandemic should ideally be rebased, or if this is not possible, an appropriate adjustment applied to model inputs or outputs in a proportionate way. Here, it clearly would have been possible at some point post-COVID and before November 2024 to have rebased trip matrices to capture post-COVID travel patterns. While Mr. Whitehouse expressed a view that a decision was taken that such analysis would not have been proportionate, there was no contemporaneous evidence of any such decision having been consciously taken, nor any reasons for such a decision having been recorded. In any event, given that it was possible for trip matrices to have been rebased, such analysis should, according to the guidance, have been undertaken. Appropriate adjustment should only be made in a proportionate way where it is not possible to rebase trip matrices, which was not the case here. In any event, the adjustment to the model considered by way of the sensitivity test was obviously deficient. The guidance makes clear that where model rebasing is judged not to be practical, analysts should assess the extent of the divergence of travel patterns and volumes from pre-pandemic projections using the best available data and evidence. If it is clear COVID-19 has had an impact on travel, this should be represented using an appropriate change in travel demand across the trip matrix, considering trip purpose and patterns as appropriate, and apply this to produce an updated core forecast. Mr. Whitehouse accepted that there were plentiful data sources available and that such analysis could have been undertaken in accordance with the guidance within the time available. Mr. Johnson has produced a raft of examples of such work having been undertaken on other schemes. Mr. Whitehouse asserted that it was not considered to have been proportionate to have undertaken that analysis. Again, there was no evidence of any contemporaneous decision-making or evidence in this respect. The guidance provides two options for making bespoke adjustments to the model using observed data. Neither of these options were carried out. Instead, a global adjustment was made to the model, that's to say a 10% reduction in cars and LGVs. Although identified by the guidance to be the simplest way of applying adjustment, it also, and I quote, presents the most risk to the model results and appraisal. This is because applying adjustments to model results means that the model has effectively not used the change in travel patterns, reflecting the changed conditions. The guidance makes clear that such a method should therefore only be considered if quick, proportionate decisions need to be taken, so long as the risks to analytical assurance are explicitly highlighted. Here there was no imperative for a quick decision to be taken, not least because the scheme has been in gestation for such a considerable period of time, and Mr. Whitehouse in any event having accepted that there was sufficient time to enable more detailed analysis to have been undertaken. The risks to analytical assurance are not acknowledged in the sensitivity test, nor anywhere else. Given that the claimed travel benefits underpin the whole purpose of the scheme, it cannot be sensibly contended that it was not proportionate in the time available and at limited cost to undertake the most detailed analysis possible of those claimed travel benefits. The use of CPO powers cannot possibly be justified, where the evidence in support of the claimed transport benefits of the scheme is so obviously inadequate. These complaints about the failure to undertake any semblance of adequate post-COVID transport appraisal are not arid or technical. Whether or not transport patterns have settled to a new normal post-COVID, there is general consensus that travel patterns are significantly different in terms of when during the day people travel and how many days a week people travel to work. That much is recognised by the government's own tag guidance. A generic 10% reduction in car and LGV journeys across the model takes no account of trip purpose or pattern, nor any account of any change to travel demand for the scheme. If, for example, as a result of new working patterns, a significant proportion of commuters are choosing to avoid travelling during the AM peak, the sensitivity test would not capture that change. If, for example, people now work from home for 2 to 3 days per week, the sensitivity test would not capture the effect on demand for the service. Indeed, there is plentiful data before the inquiry to suggest that the congestion issues that would affect buses in the do minimum scenario have improved significantly post-pandemic, such that the journey time and reliability benefits claimed for the scheme are considerably overstated. Mr. Lee has produced detailed analysis of bus journey times on Madingley Road, which demonstrates that delays in 2024 were nowhere near as severe as they were in 2019. In terms of bus patronage, the scheme is forecast to attract 8,800 new daily passenger trips, excluding trips generated by the new developments at Bourne Airfield and Cambourne West. The proposed park and ride facility has 2,000 car parking spaces and 300 bike parking spaces, assuming that all of those are taken up. It is therefore assumed that the scheme will otherwise give rise to 4,200 daily additional trips from elsewhere. That is to say, people who live elsewhere who would travel on the bus by reason of the scheme. On any view, that is a highly ambitious forecast, and one which it is impossible to analyse meaningfully in a post-COVID world without up-to-date travel data, and one which will not come about unless there are real and material transport benefits from the scheme. The applicant's response to these concerns appears to be that the tag unit guidance is relevant only to investment decision-making, and the transport-related benefits of the scheme are but a small proportion of the claimed economic benefits. Therefore, it has taken the view that updating the modelling is not proportionate in the context of the economic case. Nonetheless, the transport benefits are essential to the strategic case, which is to unlock development at Cambourne and Bourne Airfield. This scheme's entire purpose is to increase bus patronage by reducing bus journey times and variability between Cambourne and Cambridge by reference to a do minimum scenario. Unless the scheme would in fact deliver upon those objectives, that primary purpose will not be achieved. The transport-related benefits of the scheme are claimed to attract substantial weight in the planning balance and are an important factor relied upon to justify the use of CPO powers and the use of greenbelt land. It is vital that the Secretary of State's decision as to whether to make the order is based on adequate post-COVID data in order to understand whether enough people are actually going to travel on buses using the scheme to ensure new development at Cambourne and Bourne Airfield will not result in a severe degradation in the performance of the road network. As matters stand, that evidence is woefully inadequate. I turn then to the failure to assess the potential effects of East West Rail on the benefits of the scheme. In its outline business case addendum for the scheme, the applicant excluded the potential effects of East West Rail from its transport assessment on the basis that the impact on C2C is not likely to be significant. By the time of the transport assessment, the applicant's position was no longer that the impact on C2C was not likely to be significant, but rather that East West Rail was not committed and had no guaranteed funding or delivery programme. There is therefore no evidence before the Secretary of State as to the possible effects of East West Rail on the need for and benefits of the scheme. CPPF contends that it is obvious that East West Rail will significantly curtail the benefits of the scheme, principally because anyone wishing to travel between Cambourne and the Biomedical Campus or the CB1 Business District is far more likely to use the train rather than the bus, as Mr. Whitehouse accepted on behalf of the applicant. While there may be some residual benefits of the scheme for those wishing to travel between Cambourne and the villages to the west of Cambridge and the West Cambridge campus, those reduced benefits would need to be properly understood in economic terms and by reference to the environmental harms to which the scheme gives rise before any decision is made as to whether they would justify the order. The balance of benefits and harms to which the scheme would give rise would be fundamentally different in a world in which East West Rail provides a faster and more reliable journey between Cambourne and Cambridge, unaffected by the principal source of delay and unreliability on that journey, that is to say, congestion within Cambridge, which of course the scheme will do nothing to alleviate. While the applicant was at pains to make the point that East West Rail was not required to be modelled as part of the core scenario within the relevant tag guidance, CPPF contend that it should have been modelled as an alternative scenario. The guidance makes clear that when transport schemes are evaluated after opening, the evaluation results often suggest that benefits can be extremely sensitive to local sources of uncertainty, so careful consideration is essential. And I refer to some further guidance from TAG there, which I'm not going to read out. Turning to paragraph 28, in this case, East West Rail has not even been highlighted as a source of uncertainty by the applicant, let alone assessed as an alternative scenario. The fact that East West Rail does not yet have a confirmed delivery timetable is nothing to the point. The guidance makes clear that schemes which are reasonably foreseeable, but where there may be significant uncertainty, and even schemes which are merely hypothetical, may be included within the alternative scenarios. The government has reaffirmed its commitment to East West Rail in June 2025 as part of the spending review, committing £2.5 billion to the scheme. We have some very recent documents in relation to East West Rail demonstrating that continued commitment. CPPF contends that the decision whether to make the order in respect of the scheme, given the need for compulsory purchase, the incursion into the greenbelt and the environmental harms associated with it, cannot sensibly be taken without some evidence-based understanding as to the likely effects of East West Rail and whether, if East West Rail is delivered, the scheme will provide sufficient residual transport benefits to be justified. I turn then to the claimed economic benefits. Aside from the claimed transport benefits, the applicant seeks to justify the scheme by reference to what it says are wider strategic and economic benefits. In particular, the applicant claims that the scheme will unlock a considerable amount of housing development at Cambourne West and Bourne Airfield, which is claimed to be dependent on the scheme for its delivery. Indeed, in economic terms, the benefit claimed for the land value uplift taking into account costs as a result of that housing delivery, some 184 million, is significantly greater than the forecast user transport benefits, which are 71 million. It is important to note at the outset that the government itself recognises that methodologies used to calculate what it calls level 3 impacts, and that would include economic benefits deriving from land value uplift, such as I've just referred to, are often subject to a high degree of uncertainty, and the value for money framework advises that it is important that this uncertainty is rigorously assessed and transparently presented within the value for money statement. It is important that model uncertainty is examined in addition to the uncertainty of exogenous inputs, for example, by carrying out sensitivities on key model parameters. CPF considers that the land value uplift benefits claimed for the scheme are overstated and that the applicant has not properly assessed and presented the uncertainty associated with them. CPPF considers that those risks should be transparently set out for the Secretary of State before the order is made. In particular, the applicant has significantly overstated the amount of development that is dependent on the scheme for its delivery and has failed to properly identify and quantify the risk that the economic benefits claimed will be significantly lower than predicted. The applicant claims that 850 dwellings at Cambourne West and 3,000 at Bourne Airfield are dependent upon the delivery of the scheme. And I set out thereafter some guidance on dependency provided by the TAG unit. I'll only read out the first sentence, which is that the purpose of dependency testing is to determine at what point proposed site-specific developments will reach a reasonable level of service on the transport network. And then a final sentence on that extract: if development is not dependent on a transport scheme, then the need for a transport scheme should be considered solely on transport grounds as one would for a standard appraisal. Further guidance is provided in Table 3, which provides illustrations of how dependency should be assessed. And again, I'll read the final sentence in respect of a housing scheme, where the question is whether without it the existing transport system would be overwhelmed, and that's an example of the type of question that needs to be asked. Paragraph 34, the applicant has not provided any evidence that it has carried out the recommended dependency test as described in the TAG unit guidance to which I've just referred. There is nothing in the evidence before the inquiry to justify any assertion that the delivery of dwellings at Cambourne West or Bourne Airfield absent a scheme would breach a reasonable level of service on the transport network. On that basis, the applicant simply cannot make good its claim that the housing development is dependent on the scheme. Even taking the applicant's evidence at face value, however, there is no explanation in the evidence before the inquiry as to why 850 dwellings at Cambourne West are claimed to be dependent on the scheme at all. No explanation is provided in the proof of evidence of Mr. Whitehouse. As far as the underlying documents are concerned, the economic case addendum provides an analysis of the claimed land value uplift, but refers the reader to the strategic case addendum for an explanation as to dependency. When one goes to the strategic case addendum, however, there is no such explanation. At the outline business case stage, it had been assumed that 2,350 dwellings at Cambourne West would be dependent on the scheme. That assumption obviously no longer holds good, because the Cambourne West development has begun to be built out without the scheme being in place. Whatever justification there was at the outline business case stage to include delivery of dwellings at Cambourne West as dependent development cannot rationally apply to the 850 dwellings now claimed to be dependent by the applicant. CPPF contends that in the absence of any evidence that 850 dwellings at Cambourne West are dependent on the scheme, those dwellings should be discounted from the analysis. So far as the Bourne Airfield development is concerned, Condition 13 of the Planning Permission restricts occupation to no more than 500 dwellings, unless or until the scheme, or an equivalent scheme, such as a CPPF alternative, is delivered. Aside from the condition, however, there is no post-COVID transport analysis which demonstrates that in transport terms the Bourne Airfield development will still be dependent on the scheme. If transport conditions had changed post-COVID, as CPPF contends, consistent with government guidance that they have, and on analysis, it was clear that delivery of the scheme was no longer necessary to enable the dwellings at Bourne Airfield to be delivered, the developer could apply to vary that condition imposed on the planning permission. Indeed, even on the applicant's own timetable, delivery of the scheme is likely to delay delivery of the Bourne Airfield development, taking into account, for example, the need for 2 dormant seasons before the transplantation of the veteran trees at Coton Orchard can be attempted. That delay would provide the Bourne Airfield developer with the incentive to seek to vary the condition. While Mr. Sensical and Mr. Kelly suggested that the local planning authority was unlikely to permit any variation to the condition, I would add Mr. Sensical said politically unlikely. The local planning authority would, of course, have to determine the decision in accordance with its statutory duties and by reference to the available evidence. As to development referred to within the emerging local plan, such as the new allocation for development to the north of Cambourne, that development is premised upon, among other things, the delivery of a new railway station at Cambourne as part of East West Rail. The applicant does not claim that any other development is dependent on the scheme in economic terms. In terms of the amount of land value uplift claimed, CPPF also contends that the applicant has adopted an over-optimistic approach which has considered potential upside sensitivity testing, but has failed to provide any downside sensitivity testing. One of the inputs into the land value uplift analysis is the gross development value of the land following completion of the development claimed to be dependent on the scheme. In this instance, that is the dwellings at Cambourne West and Bourne Airfield. That GDV has been calculated by the applicant, and I quote, by multiplying the number of dwellings in the development area by the assumed house price per dwelling. The applicant's assessment is based on an average house price of just over £500,000 at 2024 prices, to which an annual 2.2% house price increase has been applied in the future to give an estimate of £672 million for both sites. As Mr. Lee explained in his written and oral evidence, these two inputs are inherently uncertain, and the figures used by the applicant do not reflect recent history. Whereas the applicant's assessment of house prices is based on an estimated average value of residential land, actual average house prices based on real-world data are lower, around £420,000 to £430,000. In terms of house price growth, the applicant's claimed 2.2% historical annual increase in real house prices used to project forward to the completion of the build-out is based without any clear justification on 9 years data to January 2023. Analysing land registry data for South Cambridgeshire over a full decade to July 2025, the annualised growth rate is minus 0.6%. And you have the note which I refer to at footnote 41 there. There is therefore little justification for projecting forward at a rate of 2.2% without also testing lower growth rates, including a nil growth rate. And I flag that a nil growth rate is expressly identified by MHCLG to be within a reasonable range of figures to be tested in its appraisal guide. If one removes the dwellings at Cambourne West on the basis that there is no evidence that they are dependent on the scheme, and assume a lower average house price and 0% house price growth, the land value uplift associated with the scheme would give rise to a benefit cost ratio of just 0.5. Even if one assumes in the applicant's favour 2.2% house price growth, but excludes Cambourne West and assumes a lower average house price, the BCR for the scheme is only 1.1. CPPF contend that these scenarios are, at the very least, realistic possible outcomes and serve to demonstrate, in accordance with the TAG guidance, that the economic benefits claimed for the scheme are highly sensitive to relatively minor changes in the assumptions underlying the inputs. Not only should these alternative scenarios have been considered by the applicant, but they should now be considered by the Secretary of State in the decision whether to make the order. The economic benefits which are said to justify the scheme are highly uncertain, and the economic case for the scheme is speculative. I turn then to the carbon benefits. Throughout the genesis of the scheme and at this inquiry, the applicant has claimed that the scheme will give rise to carbon savings. It is clear from the evidence of Mr. Kelly on behalf of the district and city councils that these claims have had an impact on the decision-making process. Upon analysis, the carbon saving claims are obviously wrong. The evidence demonstrates that the scheme will be a net emitter of carbon. With regard to the carbon assessment, the environmental statement has failed to provide a reasoned conclusion on the significant effects of the works on the environment, taking into account current knowledge and methods of assessment as required, insofar as it used outdated fleet composition data and relied on unreasonable methods of assessment. The carbon assessment in the ES failed to use the correct TAG data book for the composition of the fleet. Forecasts of the likely proportion of electric vehicles by comparison to petrol and diesel vehicles, that's to say the fleet composition, are key to the assessment of carbon emissions, because the carbon savings claimed for the scheme derive to a significant extent from the number of kilometres driven by petrol diesel cars which will be saved by virtue of the scheme. The greater the proportion of EVs within the fleet, therefore, the lower the carbon benefits of the scheme. The ES records that the relevant tag data was accessed on the 3rd of November 2022 and that the dataset was taken from the May 2022 tag data book. The difficulty with that position is that at the time the data was accessed, an updated data book was already available, dated November 2022 but released in May 2022, on the same web page, and the guidance accompanying the release made clear that where your work is due to report after this date, you should work to the updated values or guidelines if it is appropriate to do so, following guidance in the proportionate update process. Given that, at the time the data was first extracted for the purpose of the ES, that's to say 3rd of November 22, the new tag data book had been released, and the work was due to report after the data book came into force. It is this data that should always have been used as the basis of the assessment. While it would have been proportionate to use updated values in any event, there should never have been any need to update the values. The carbon assessment calculated carbon savings for a single future modelled year and applied these savings to every subsequent year in the period. The combination of this method and the use of outdated fleet composition assumptions means that the 5,000 odd ton saving in the ES is based on an assumption that electric vehicle uptake would only reach 27% by 2085. It should have been clear that such a result was unreasonable, especially given that even the outdated 2022 tag data assumes EV uptake of 44% by 2050. Had the applicant used the correct data or reasonable methodology at the time of the ES would have demonstrated that the scheme would give rise to significant carbon emissions rather than demonstrating a carbon saving, because the updated tag data book projects a much more rapid take-up of EVs than did the May 2022 data. While this calculation was never performed by the applicant, Professor Hurst provided a reasonable extrapolation, finding net emissions of some 10,000 tonnes of carbon. It is highly regrettable, we say, that rather than simply accepting that a mistake was made, Mr. Saunders sought to defend the approach taken by WSP on behalf of the applicant. That defensiveness has done little to inspire public confidence, as articulated by Professor Hurst, in the information put forward by the applicant. The applicant has since produced further evidence to predict net carbon emissions from the scheme. In an appendix to his proof of evidence, Mr. Saunders produced an updated assessment which suggested that using the most recent tag data book, May 2025, applied to the F-series model, the scheme would give rise to a reduction in carbon of some 7,000 tonnes. The applicant has never provided a sensible explanation for the large increase in calculated carbon recovery when changing from the E-series to the F-series model of the CSRM, which further calls into question the reliability and validation of the transport modelling underpinning the assessment. And in any event, this calculation uses the same flawed methodology as the original ES, in that carbon savings are calculated for a single model year and applied to all subsequent years. Finally, in October 2025, the applicant carried out a further assessment using a method provided for in the latest QCG guidance, which demonstrated that the reduction in carbon would be just 1,400 odd tonnes of carbon with projected payback in 2084. Even that carbon saving of some 1,400 tonnes assumes that the take-up of EVs increases steadily until 2050, but at that point then remains constant at 82% of the fleet for the remainder of the assessment period. Mr. Saunders accepted in cross-examination that this assumption is, and I quote, unrealistic. The applicant sought to defend the use of the data in this way, notwithstanding that Mr. Saunders accepted that the results it produced were unrealistic, by reference to the CQC guidance, on the basis that if the trend in EV take-up between 2041 and 50 were extrapolated beyond 2050, this would imply that EV take-up would exceed 100%. The applicant's approach on this point was, frankly, absurd. The only sensible way to apply the relevant QCG guidance is to extrapolate the trend in EV take-up between the final 2 model years until such time as EV take-up reaches 100%, or some figure very close to that, to account for the possibility of a very small number of residual non-EV vehicles in the fleet, and then calculate the carbon savings for the remainder of the assessment period based on a fleet composed entirely or nearly entirely of EVs. As Professor Hurst pointed out, a further alternative would be to use alternative data, such as that provided in the Common Analytical Scenarios databook, which gives a figure of 99% in 2050 of EV take-up. The CAS scenarios are central, and I quote, to how DFT intends to approach uncertainty in transport analysis, and could have been applied in this case to identify the sensitivity of the assessment to the unrealistic post-2050 fleet composition used by the applicant. Either way, as Mr. Saunders accepted, if the assessment were carried out in this way, and it's notable that even by the end of the inquiry, Mr. Saunders had failed to produce any assessment on this basis, it is clear that the very small carbon saving which the applicant currently predicts will be wiped out and would demonstrate that the scheme will be a net carbon emitter. This is a matter which should be weighed against the scheme, notwithstanding whether there is a strategic fit of the scheme with other outcomes, as was accepted by Mr. Sensical in his cross-examination, and as a QCG guidance in any event makes clear, irrespective of any strategic fit, and I quote, the net impact of schemes should not be dismissed. It should be a key consideration in determining carbon management and scheme prioritization. It will be regrettable if, in closing, the applicant fails to acknowledge what is obvious to anyone who has followed the evidence in relation to carbon emissions, that is to say, that the scheme will be a net emitter of carbon, and instead maintains its position that the scheme will be carbon positive. Either way, CPPF considers it to be important that the carbon emissions from the scheme are properly assessed and weighed in the balance in the decision whether to make the order. I turn then to the access and maintenance track. CPPF maintains that there is no requirement for the scheme to be accompanied by an access and maintenance track, and that the compulsory purchase of the land required to deliver it cannot be justified. As Mr. Littlewood explains in his proof of evidence, there is no reason why maintenance and emergency vehicles cannot use the busway itself. Indeed, in the case of emergency vehicles, there is every likelihood that they will use the busway rather than the track, which will be separated from the busway by ditches, trees, and other landscaping, given that it is likely to provide the quickest, safest, and most direct means of reaching any emergency. The notion that an emergency vehicle would travel down the maintenance track, thereby coming into conflict with pedestrians and cyclists and necessitating the crossing of landscape to reach the busway, is unrealistic. So far as maintenance is concerned, Mr. Lonergan accepted that the BritPAVE guidance was not applicable to the scheme as it is not proposed to be curb guided, and that it was possible that maintenance could be carried out using the busway, subject only to disruption to services. After all, roads up and down the country are maintained without the need for any separate maintenance track. In reality, any disruption to services caused by reason of maintenance activities is likely to be minimal. The number of buses travelling along the busway is very low by comparison with other roads, and in the event of the need for traffic management, for example, when flows along sections of the busway are reduced to a single direction to enable maintenance to take place in the busway, the likelihood of conflicts between opposing vehicles is low. Even if such a conflict did arise, the delay to a service would be minimal. Such other benefits as were claimed for the maintenance track, such as that it would allow for the laying of utilities beneath it, cannot possibly justify the use of CPO powers. In terms of its function as an active travel path, it is important to bear in mind that an order may only be made in respect of matters relating to or ancillary to the types of development specified in Section 1 of the Act. An active travel path is not a matter related to or ancillary to a busway, and so that function of the track would not, in isolation, fall within the scope of the powers for which an order may be made. Further, CPPF maintains that the benefits of an active travel path alongside the busway are limited. As Mr. Littlewood has explained, there is a far more attractive active travel route known as the Cambourne Greenway, which is currently being constructed as far as Hardwick and which could easily be extended to Bourne Airfield through Highfields Caldecott by way of the upgrading of existing public bridleways, and without the need for any further acquisition of land. This route would be far more attractive to the majority of pedestrians and cyclists, as it would not run alongside a busway, would provide a more direct route between Cambourne, Bourne Airfield and West Cambridge, and would avoid a steep incline on Madingley Hill. The construction of an access and maintenance track increases the land take required by around 30%, with a commensurate increase in environmental and other harms, because it is essentially a third lane of road. These significant harms can and should be avoided by not building the unnecessary access and maintenance track. The only public benefit which could justify the harms caused by the track is its use as an active travel path, and this benefit can be provided by the applicant in other ways without significant harm. I turn then to the CPPF alternative. As part of its case that the order should not be made, CPPF CPC contend that there is an alternative in-highway scheme, I refer to as the CPPF alternative, for the section of the scheme which comprises the offline busway between St Neots Road, immediately west of the Madingley Mulch roundabout, and the Madingley Park and Ride junction, which would, subject to refinement through detailed design, be significantly less harmful in environmental terms, cheaper and deliverable in a timeframe comparable to that of the scheme and aligned with the build-out of Bourne Airfield. There is no dispute between the parties that, in principle, the availability of a deliverable alternative which would avoid the need for CPO is a material consideration for the Secretary of State. It would be irrational for the Secretary of State to make an order requiring the compulsory purchase of land if there is an alternative scheme which would achieve the same objective, having taken into account all relevant considerations. It is important to take into account any proposals which the landowner has for its own land, and here CPPF has its own plans to use its land as a nature reserve. At the outset, it is important to record those issues in respect of which there has been express agreement between CPPF and CPC and the applicant, as well as those issues which have not been the subject of any challenge from the applicant. I start then with the scheme objectives and transport benefits. First, there has been no challenge by the applicant to the evidence given by CPPF CPC that the CPPF alternative would deliver upon the objectives for the scheme and would fulfil the relevant planning policy requirements. As both Mr. Littlewood and Mr. Lee explained, while policy SS7 of the South Cambridgeshire local plan requires improvements in public transport between Cambourne and Cambridge in relation to the Bourne Airfield allocation, section of route in question, the policy requirement is for the provision of high-quality bus priority measures or busway on or parallel to the A1303 between its junction with the A428 and Queen's Road. The CPPF alternative would fulfil this requirement, and there has been no suggestion to the contrary from the applicant nor challenge to this evidence. Similarly, policy SS8 in relation to the Cambourne West allocation requires high-quality segregated bus priority measures on the A1303. Again, the CPPF alternative would fulfil this requirement, and there has been no suggestion to the contrary from the applicant, nor any challenge made to this evidence during the cross-examination of Mr. Littlewood or Mr. Lee. So far as the Bourne Airfield development itself is concerned, the CPPF alternative would fulfil the requirements of both Condition 13 of the relevant permission and the Section 106 agreement, which both refer to the scheme or, and I quote, an equivalent scheduled rapid mass transit passenger carrier service. Again, there was no challenge to this evidence from the applicant. As the emerging local plan, references to the scheme, whether in the introductory parts of the plan or in the various draft allocations, do not impose any particular requirements for the scheme, and a scheme which included the CPPF alternative would equally fulfil the requirements of the emerging plan allocations, as does the scheme. Again, there has been no suggestion by the applicant, or indeed South Cambridgeshire, that a scheme which included the CPPF alternative would be in conflict with the emerging local plan policies, or that the planning policy requirements or objectives in the emerging local plan could not be delivered. In terms of the objectives for the scheme and the transport benefits, the CPPF alternative would deliver equivalent transport benefits to those provided by the scheme, as Mr. Lee has explained in detail in his report at section 3.5, and would indeed deliver benefits over and above the scheme, as he explains at section 3.6. As to the fact that the CPPF alternative would include an inbound bus lane but not an outbound bus lane, Mr. Lee has explained in detail why an outbound bus lane is not required now and will not be required in the future by reason of the constraints on outbound flows. Any assumption that flows will increase significantly is in any event contrary to the aims and objectives of national planning policy and the emerging local plan. Again, there was no challenge to any part of this evidence in the cross-examination of Mr. Lee, nor has the applicant presented any of its own evidence in relation to these matters. Environmental harms. There can be no sensible dispute that the CPPF alternative is very substantially less environmentally harmful than the scheme. It would avoid any impact on the openness of the greenbelt, involving a minor widening of an existing road corridor. It would avoid the impacts on landscape character caused by the scheme. It would avoid what are acknowledged by the applicant to be significant impacts on Coton Orchard at a county scale. It would avoid the need for compensation for damage to 3 other designated local wildlife sites. It would avoid any impact on veteran trees, protected species including bats and the other species that would be affected by the scheme, and would avoid any impact on the Madingley Wood SSSI. Both Ms. Reason in relation to bats and Mr. Whitby in relation to the other affected species accepted that the CPPF alternative was, by reference to the mitigation hierarchy, preferable in ecological terms to the scheme because it would avoid any impacts to protected species and habitats, whereas the scheme will give rise to impacts which are required to be mitigated. So far as bats are concerned, and notwithstanding the position adopted by Natural England, it remains the case that the mitigation proposed to address the impact on bats in the form of bat hopovers is scientifically unproven. Ms. Reason accepted that there was, at the very least, uncertainty as to its efficacy. Indeed, the latest scientific evidence suggests, in fact, that bat hopovers may increase the risk to barbastels by encouraging them to cross roads at unsafe heights. So far as the scheme is concerned, the ES has failed to properly account for the amount of Coton Orchard which comprises traditional orchard, a priority habitat, and there are other failings in the assessments of other sites. The effects from the scheme will therefore be worse than the applicant has predicted, and the CPPF alternative is commensurately preferable. In respect of BNG, the metric calculation upon which the results submitted with the application were based was defective in a number of significant ways, not least insofar as it omitted to account for individual tree loss, as was accepted by Mr. Whitby to be an error. It is accepted by the applicant that to deliver a net gain, off-site habitat units are going to be required to be purchased, and due to the need to correct such errors, a greater number of units will now be needed than assumed in the application. Even assuming that sufficient habitat and hedgerow units are available at Lower Valley Farm, and that sufficient watercourse units are available elsewhere, the purchase of such units will give rise to a significant additional cost to the project. Mr. Whitby accepted that to account for the habitat units required to mitigate individual tree loss alone, the likely additional cost could be in the order of £1 million. The contingency for the project is some £37.9 million. It is remarkable that such a large amount of that contingency could be taken up to account solely for just one of the errors in the BNG assessment. So far as the need for watercourse units is concerned, their availability is limited, and there is no concrete evidence that there will be such units available to the scheme. On any view, the delivery of a net gain will be easier and cheaper to deliver by way of the CPPF alternative. In terms of the heritage impacts from the CPPF alternative, it would avoid harm to the Coton Conservation Area, as has been accepted by the applicant, but would cause some harm to the setting of the American Military Cemetery Registered Park and Garden. CPPF and CPC contend that no harm would be caused to the memorial, whose boundary is some distance away from the road and whose heritage significance is visually separated from the road by a large wall. Mr. Wilson's evidence on behalf of the applicant was, in any event, that any harm to the heritage significance of both assets as a result of the loss of some of the verge between the current carriageway and the boundary hedge of the cemetery, which is all that the CPPF alternative would require, was in the less than substantial category for the purposes of the MPPF and on the low side of less than substantial. Mr. Sensical accepted that, by reference to paragraph 215 of the MPPF, the public benefits of the scheme would outweigh that level of harm to the significance of the heritage asset. The CPPF alternative would therefore be compliant with national policy in respect of heritage assets, and such limited effects as there would be on the setting of the registered park and garden would not be a reason to refuse permission for the scheme, nor a reason as to why the CPPF alternative would not be deliverable. Sirs, can I just very briefly pause there, because I realise in the introduction at paragraph 5e, I assert that the CPPF alternative would preserve the significance of heritage assets. I think to avoid any inconsistency, I need to cross out paragraph 5e and e.
Yeah.
And if I can ask you, please, simply to replace it with the final sentence that I've just referred to, please, which I now need to find it. I'm sorry, Mr. Cameron.
I think was it the second paragraph? Sorry, the second sentence of paragraph 71.
Yes, sorry. There's probably some very long sentences there. It's the sentence that begins 3 lines up on page 26. From the bottom of 26, the CPPF alternative would be compliant.
So you want that sentence to moving forward?
Yes, if that sentence, I appreciate it's not particularly pithy, but just to ensure consistency between what I say at paragraph 5 and in the body of the submission, yes. If that sentence could just replace what's at paragraph 5e currently.
So suppose twice, keep it there.
Yes, or yes, either repeat it or just delete paragraph 5e. So then carrying on at the top of page 27, while a considerable amount of time at the inquiry was spent examining a letter written from the British to the US governments in relation to the cemetery, it is clear that the CPPF alternative would not incur into any of the pink land shown on the plan attached to the letter. The pink land, as shown on that plan, cannot sensibly include any of the highway maintainable at public expense, and the CPPF alternative would not incur beyond that highway land at any point along the boundary of the cemetery. There will be no injury to any of the rights or obligations contained within the letter. As noted above, the CPPF alternative will be preferable in terms of its carbon impacts, irrespective of whether a new bridge over the M11 is required, and there will be no impact on best and most versatile agricultural land. Taking all of these factors into account, there can be no sensible dispute that the CPPF alternative has substantial advantages. It would comply with the relevant planning policy framework, deliver equivalent transport benefits, and would avoid the litany of environmental harms associated with the scheme. The only real matter of dispute between CPPF and the applicant was the extent to which the CPPF alternative would accommodate a safe and suitable highway arrangement, which was feasible to construct within a timescale that would not give rise to any delay in the delivery of the benefits. While the applicant, through evidence given by Mr. Lonergan, has sought at every turn to identify what are the obstacles to the delivery of the CPPF alternative, very little energy, if any, has been devoted by the applicant to any analysis as to how the constraints upon the delivery of the CPPF alternative could be overcome so as to avoid the harms associated with the scheme. In that context, it is important to bear in mind, as was explained by Mr. Lee, that the purpose of the CPPF alternative is not to provide a fully worked up scheme, but rather to demonstrate that such a scheme is feasible in principle. Clearly, detailed design work would need to be undertaken and amendments would be made, as would be the case for any scheme. CPPF and CPC accept that the CPPF alternative will involve the need for some departures from DMRB standards, but, as Mr. Lonergan accepted, such departures from standards are not in principle unusual and are part of the DMRB process. After all, the existing road is not compliant with the DMRB standards, and the scheme itself requires some departures from standards. Mr. Lonergan accepted that the question of whether a departure from standards will be justified would need to be taken in the round by reference to a number of factors, including the size of the risk to the travelling public, impact on flows, capacity, wider impact on the network, cost, environmental effects, and other benefits that may accrue. As to the proposed reduction in the speed limit to 40 miles per hour, this would accord with the County Council's speed policy, as there is a strong environmental and landscape reason for the reduction in speed, and there is nothing otherwise, so far as the functional nature of the road is concerned, that would make a 40 mile per hour speed limit inappropriate. Reducing the speed limit is likely to increase the capacity of the road, and the fact that the route is part of the diversion route of the SRN does not mean that a lower speed limit is inappropriate. Running buses at 40 miles per hour rather than 50 over 1.3 kilometres will make a minimal difference to journey times, and it may well be that speeds along this section of the road, in particular around peak times, are closer to 40 miles per hour in any event. But the absence of speed surveys undertaken by the applicant mean that it is impossible to know. In terms of the departures from standards required, Mr. Johnson explained by reference to the table appended to Mr. Lonergan's report, that departures D1 to D5 all related to the same cross-section and would involve the approval of reduced lane and verge widths. Mr. Johnston was confident that in conjunction with the reduction in speeds to 40 miles per hour, the provision of reduced lane widths, in particular of the main carriageway to 3.25 metres, and can I add from 3.65 metres, was safe.
3.6.
I think it is, yes.
Okay, thank you.
And that the reduction in lane widths and speed limits were complementary and self-enforcing. So far as the other departures were concerned, D6 to D13 related to minor departures in respect of reduced visibility at junctions, which was commonplace in respect of private accesses along an existing route. Traffic flows into these accesses were likely to be low, and for the most part undertaken by those who were familiar with the road characteristics. Departures 14 to 17 were matters of detailed design. Thus, while Mr. Lonergan sought to emphasise the number and significance of departures required to deliver the CPPF alternative, CPPF contend that the alternative would deliver a scheme that is both safe and suitable. In terms of its construction feasibility, while Mr. Lonergan had raised a number of issues in his written evidence, he ultimately accepted in cross-examination that it was possible that the scheme could be delivered as shown on the civilistics drawings, subject to disruption and cost. In relation to overhanging trees, branches could be pruned. In relation to verges, the verge could either be retained, ditches culverted, or re-provided. In relation to potential issues of super-elevation, the existing service of the carriageway could be lowered rather than raised. In relation to concerns about drainage, the amount of additional carriageway required was limited, and it may well be that the existing ditch network has sufficient capacity to accommodate any increased runoff. Alternatively, there was a possibility of above-ground SUDs, possibly on land owned by CPPF. Pipework was a measure of last resort and unlikely to be required, but if it was, would be limited in scope. It was a challenge that could be readily overcome. Utilities would run down the shared footpath cycleway and would be readily accessible. While there would be some inevitable disruption while the scheme was constructed, it could be built in sections using overnight weekend work where possible. It would likely be possible to maintain two-way flows of traffic during the construction period. The construction of an entirely new carriageway would reduce maintenance requirements for the new road, and the cost of such a scheme would inevitably be less, I would say significantly less, than for the scheme. In terms of the crossing of the M11, it is acknowledged that the existing arrangements are constrained. However, the applicant has already explored the feasibility and cost associated with a new pedestrian bridge over the M11, which would require minimal additional land, if any. Mr. Lee also explained that it was possible that adjustments to the M11 off-slip and signals could also be made to avoid the need for any new infrastructure. In terms of delivery, Mr. Lee's estimate was that the CPPF alternative could be delivered in its entirety within 5 years of the date of the decision from this inquiry, and that parts of the alternative could come forward sooner, so as to bring forward the benefits associated with them. The applicant's estimate for the scheme itself is that it will come into operation 2.5 years after any decision by the Secretary of State, although this does not account for the fact that construction of the section through Coton Orchard could not begin at the earliest until November 2028, given the preparation works for the transplantation of the veteran trees in the orchard. There would be no undue delay in the delivery of the CPPF alternative in such a way as to cause any material harm to the delivery of the scheme's objectives. Taking everything together, CPPF and CPC acknowledge that there are constraints on the delivery of an in-highway scheme, whether the CPPF alternative or some variant of it. CPPF and CPC, however, urge the Secretary of State to consider whether the additional cost and environmental harm to which the scheme will give rise, including the compulsory purchase of land, incursion into the greenbelt, loss of priority traditional orchard, deterioration or loss of irreplaceable veteran trees, and a suite of other environmental harms can be justified, given the availability of an alternative scheme which achieves equivalent benefits at significantly less cost. Finally, public open space. In the event that the Secretary of State agrees that the maintenance track is not required, there will be no public access to the proposed replacement open space. If access were provided solely via the new bridge, then CPPF-CPC contends that the proposed area of replacement public open space would not be a good location to encourage public access and dwell time, as it would be isolated with no surveillance and includes a balancing pond. CPPF and CPC contends that land owned by CPPF will be preferable replacement open space, as shown in Mr. Littlewood's proof of evidence, for the reason given in his proof. Finally, conclusion. For all the reasons set out above, you, sirs, are respectfully invited to recommend, and the Secretary of State invited to find, that the order should not be made, the request for deemed planning permission be refused, and the application for the public open space certificate dismissed, or alternatively, that provision in respect of the maintenance and access track should be removed from the scope of the order and permission for it refused. So, unless I can assist you further, those are my submissions.
Thanks, Mr. Parker. Just one query. I want to go back to the point where you interrupted yourself on page 2, 5E. I think you gave 2 alternative versions. It's got to be one version that everybody's clear about.
Yes.
So, I got the impression that you're ending up saying just delete 5E.
Well, I think although it would be repetitious, I would ask that you just simply replace this sentence.
From page 17.
Yeah, and I appreciate that will be repetitious, but
no, as long as we all understand.
Yes,
that's the main thing.
That's my final position.
And it's the sentence it's towards the bottom. Hopefully it's the right sentence next.
Yes, so it's at the bottom of page 26. Yeah. Paragraph 71, it begins, the CPPF alternative would therefore be compliant with national policy.
So the whole of that sentence up to the top of page 27?
Yes, to the word deliverable, yeah. If I were rewriting this, sirs, I might do it differently, but in the time available, I think that ensures consistency.
That's in Friday. Thanks.
Thank you, Mr. Parker.
So if we're about finished, I've got one matter to raise, nothing to do with Mr. Parker's submissions.
Yes.
I gather, so I'm told, instructed, that Anglian Water have made a submission to you, the inspectors. We haven't seen it, but if it's been made, please could it be made available before we make our closing submissions?
It was brought to my attention. My understanding was it was just repeating their position that at this opening of the inquiry they had a holding objection, and I think they're just saying that at the close of the inquiry they got a holding objection, but they've made lots of progress. But
Well, that's fine, sir, but it's just a question of whether the rest of us can see it.
yeah, well, there's no, yeah, it doesn't introduce anything. I think the attachment is just repeating their objection. So we'll make that available. Is there anything else that anybody wants to raise at this stage? In terms of things, just to pick up after the conditions session, there is a number of conditions I think that the applicant was going to redraft.
There's two, sir.
Yeah.
The BNG condition 15, and we've then consolidated 19, 20, and 22. Mr. Roberts has done that whilst we've been doing other things, so I need to have a quick chat to him and to my client, and then we'll get those over to you this evening as the plan.
Thank you. And there was also the issue that I think was raised right at the start of the conditions session about the timescale and the implications.
We'll pop that in the same email, sir.
Right.
So
have you reached a view on that yet, or is that something still looking
just
at?
have to have 2 minutes chat. We'll put it in the email.
I think those were the elements that we're waiting for.
There was a few other things. You want the Womblebond Dickinson letter about 100 ZA, etc. We've got all that in hand.
Yeah, and then again, I think there was the sort of the revisions to the order that
we've got that in hand. We're doing a list of plans and giving you an answer on the busway point in work number 1.
Okay, good.
Those are the 2 points, all in hand.
Thank you. Well, in that case, if there's nothing else to raise, we'll resume tomorrow at 9:30, where we'll hear the two councils' closing statements, and then it'll be from the applicant. So thank you very much. The inquiry is now adjourned, and we'll resume tomorrow at 9:30. Thank you.